House to come to order. Members, proceed to your seats. Will the members please rise to the invocation delivered by Pastor Tom Troth, Hillcrest Baptist Church of Frankfort, Kentucky, and remain standing for the Pledge of Allegiance.
Happy St. Patrick's Day. Let's pray. Our Father in heaven, as we pray for your guidance and help, we know that it takes prayer and action to accomplish your purposes on this earth. Lord, help us to pray as if it all depended on you and work as if it all depended on us, that we may do that which is pleasing in your sight. Deliver us from discouragement, and when we feel most helpless, help us to turn to you for answers. Enable us to see issues with an eternal perspective. Help us to choose what is right and rely upon you rather than choosing between evils. Give us the boldness of a faith that has conviction. Remove fear from us other than the fear of not doing your will. We ask this in the name of Jesus, who died for us all. Amen.
I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Clerk will sound the chimes. Members, indicate your presence. Clerk will take the roll. Being 95 members indicating their presence, a quorum is declared and the House is ready to proceed. Next order of business, the excuse of absent members. Gentleman from Taylor.
Mr. Speaker, I move you, sir, that the absent members be excused in accordance with the House rules.
Without objection, so ordered. Gentleman from Taylor.
Mr. Speaker, I move to suspend the rules for the purpose of allowing members to co-sponsor bills and resolutions or to submit vote modifications and have filed the proper papers with the clerk to do so.
Without objection, so ordered. Next order of business, the approval of the journal. Gentleman from McCracken.
Mr. Speaker, I yield to the Clerk of the Senate.
Chair recognizes the Clerk of the Senate. Good afternoon, Madam Clerk.
Good afternoon, Mr. Speaker. Happy St. Patrick's Day.
You as well.
We have been busy. The Senate has passed Senate Bills 77, 147, 149, 222, 224, 225, 233, 249, 251, 278, 289, and 333, and Senate Concurrent Resolution 66 and Senate Joint Resolutions 75, 134, and 139, and respectfully request concurrence from this honorable body. And, Mr. Speaker, the Senate has passed House Bill 290 with letter. And respectfully request concurrence of this honorable body.
Y'all have been busy.
There you go.
Thank you, Madam Clerk.
Thank you, sir.
Hey, welcome.
Gentleman from McCracken.
Mr. Speaker, I move you, sir, that the journal from Monday, March 16, 2026 be approved.
Without objection, the journal from Monday, March 16, 2026 is approved. Next order of business, the second reading of bills. There being no need. Next order of business, report of committees. Clerk, please report.
The Appropriations and Revenue Committee has met and reports Senate Bill 57 should pass to rules, an act relating to nuclear energy development. Senate Bill 69 should pass to rules with House Committee Substitute 1, an act relating to the Autism Spectrum Disorder Trust Fund and declaring an emergency. House Joint Resolution 81 should pass to rules with House Committee Substitute 1, a joint resolution authorizing the release of funds and declaring an emergency. The Local Government Committee has met and reports Senate Bill 20 should pass, an act relating to city government. Senate Bill 40 should pass to rules, an act relating to public library districts, boards of trustees. Senate Bill 141 should pass to rules, an act relating to legal advertisements. Senate Bill 755 should pass to rules with House Committee Substitute 1, an act relating to associations and individual representation rights. House Bill 851 should pass to rules, an act relating to reporting requirements. The Post-Secondary Education Committee has met and reports Senate Bill 22 should pass with House Committee Substitute 1, an act relating to the Dual Credit Scholarship Program. House Bill 298 should pass, an act relating to KEYS scholarships for students attending non-certified schools. Senate Bill 766 should pass to rules with House Committee Substitute 1 and House Committee Amendment 1, the title amendment, an act relating to student housing. House Bill 826 should pass to rules, an act relating to adult education. The Transportation Committee has met and reports Senate Bill 110 should pass with House Committee Substitute 1, an act relating to motor vehicles. House Bill 601 should pass to rules, an act relating to highway access. The Veterans, Military Affairs, and Public Protection Committee has met and reports Senate Bill 11 should pass, an act relating to a residential safe room rebate program. Senate Bill 104 should pass, an act relating to impeding a first responder. And House Bill 767 should pass to rules, an act relating to emergency management and declaring an emergency.
Thank you, Mr. Clerk. All those bills and resolutions receiving favorable committee reports shall be considered as having their first reading and are ordered placed upon the calendar. Those bills having received a previous reading shall be considered as having their second reading and are ordered in the possession of the Rules Committee for further action. Those bills having received two previous readings are ordered in the possession of the Rules Committee for further action. Next order of business, the orders of the day. Gentleman from McCracken.
Mr. Speaker, I move you, sir, that House Joint Resolution 81 be taken from the Committee on Rules and placed in the orders of the day.
Without objection, so ordered. Gentleman from McCracken.
Mr. Speaker, I move you, sir, that House Bill 683 be taken from its place in the orders of the day, read for a third time, by title, and sponsor only, and placed upon its passage.
Motion's made and seconded that House Bill 683 be taken from its place in the orders of the day, read for the third time by title and sponsor only, and placed upon its passage. Clerk, please report.
House Bill 683, an act relating to recreation and tourism development. Representative Upchurch.
Gentleman from McCracken.
Mr. Speaker, I yield to the gentleman from Wayne for explanation of the bill and motion thereon.
Chair recognizes the gentleman from Wayne for explanation of bill and a motion thereon.
Thank you, Mr. Speaker. House Bill 683 establishes the Burnside Island Development Authority for the purposes of pursuing a P3 partnership with companies that would build a resort, hotel, restaurant on Burnside Island. I'll be happy to answer any of the questions. Otherwise, I'd move for passage of House Bill 683.
Question before the body is passage of House Bill 683. Is there any discussion? Seeing none, clerk will sound the chimes. Those in favor vote aye. Those opposed, nay. Roll call is open for your vote. Have all members voted? Does any member wish to change or explain their vote? Clerk will take the roll. Being 94 members voting aye, no members voting nay, House Bill 683 is passed. Gentleman from Wayne.
Move the clincher.
Without objection, so ordered. Gentleman from McCracken.
Mr. Speaker, I move you, sir, that House Joint Resolution 81 be taken from its place in the orders of the day, read for a third time by title and sponsor only, and placed upon its passage.
Motion is made and seconded that House Joint Resolution 81 be taken from its place in the orders of the day, read for the third time by title and sponsor only, and placed upon its passage. Clerk, please report.
House Joint Resolution 81, a joint resolution authorizing the release of funds and declaring an emergency. Representative Bray.
Gentleman from McCracken.
Mr. Speaker, I yield to the gentleman from Rockcastle for explanation of the resolution and motion thereon.
Chair recognizes the gentleman from Rockcastle for explanation of resolution and motion thereon.
Thank you, Mr. Speaker. Would you please have the clerk report House Committee Substitute 1?
Clerk, please report.
House Committee Substitute 1 to House Joint Resolution 81.
Gentleman from Rockcastle.
Move adoption.
Motion is for the adoption of House Committee Substitute 1. Is there any discussion of the committee substitute? Seeing none, those in favor signify by voting aye. Aye. Those opposed, nay. No. House Committee Substitute 1 is adopted. Gentleman from Rockcastle.
Thank you, Mr. Speaker. House Joint Resolution 81 is the authorization of funds as they've been scored by the Kentucky Infrastructure Authority through the Kentucky Waters Program that we set up in 2024. We simply took their list that they had recommended funding, went through it, capped some administrative expenses, and authorized all the projects as far as the money would go. And with that, Mr. Speaker, I would move passage of House Joint Resolution 81 as amended by House Committee Substitute 1.
Question before the bodies. Adoption of House Joint Resolution 81. Chair recognizes the gentleman from Johnson for discussion of the matter.
Thank you, Mr. Speaker. Could I ask the gentleman a question?
He will yield.
Thank you, Mr. Speaker. Gentleman from Rockcastle, would Martin County happen to be on this list?
Gentleman from Rockcastle.
Yes, sir. Martin County is in fact on this list. They have about $25.8 million in projects to be funded through the Waters Program.
Gentleman from Johnson.
Thank you, Mr. Speaker. Can I speak just briefly? Thank you for this opportunity. The people certainly will be pleased. Thank you, gentlemen from Rockcastle, for your hard work. I'm so happy today. I'm good. Thank you.
Question before the bodies. Adoption of House Joint Resolution 81 as amended by House Committee Substitute 1. Is there any further discussion? Seeing none, clerk will sound the chimes. Those in favor vote aye. Those opposed, nay. Roll call is open for your vote. Have all members voted? Does any member wish to change or explain their vote? Clerk will take the roll. In 95 members voting aye, no members voting nay, House Joint Resolution 81, as amended by House Committee Substitute 1, is passed. Gentleman from Rockcastle.
Move the clincher.
Without objection, so ordered. Gentleman from McCracken.
Mr. Speaker, I move you, sir, that House Bill 781 be taken from its place in the orders of the day, read for a third time by title, sponsor only, and placed upon its passage.
Motion is made and seconded that House Bill 781 be taken from its place in the orders of the day, read for the third time by title and sponsor only, and placed upon its passage. Clerk, please report.
House Bill 781, an act relating to the Supplemental Nutrition Assistance Program Education and Training Plan. Representative Lockett.
Gentleman from McCracken.
I yield to the gentleman from Jessamine for explanation of the bill and motion thereon.
Chair recognizes the gentleman from Jessamine for explanation of the bill and a motion thereon.
Thank you, Mr. Speaker. Would you please have the clerk report House Committee Substitute 1?
Clerk, please report.
House Committee Substitute 1 to House Bill 781.
Gentleman from Jessamine.
I move for adoption.
Motion is for the adoption of House Committee Substitute 1. Is there any discussion of the committee substitute? Seeing none, those in favor signify by voting aye.
Aye.
Those opposed, nay. House Committee Substitute 1 is adopted. Gentleman from Jessamine.
Thank you, Mr. Speaker. The MAHA Task Force heard from a lot of people about our SNAP program in Kentucky. It was and it still is our desire to offer incentives to eat healthier and to change habits surrounding our food consumption. We do know that the following is true. One, high workforce participation is directly tied to a healthy and nourished population. Number two, to maximize the value of SNAP on healthy and nourishing food is the most economical choice and increases the overall health of Kentuckians. And number three, the federal government provides 100% matching grants for qualified private partner-funded SNAP employment and training programs. And the Commonwealth has recognized this opportunity to provide both employment training and nutrition incentives. Therefore, we are committed to bringing potential partners to the table through a working group of public and private entities to explore all options for increasing workforce engagement, as well as incentive programs for SNAP participants. House Bill 781 is just the first step and establishes the framework by which this work group, in coordination with the Cabinet, will explore these initiatives under Kentucky's SNAP Employment and Training State Plan. This uses no state funds and is simply a federal match of private funds. From this working group, we will see additional ideas and framework for these initiatives. So, Mr. Speaker, if there are no questions, I move for passage of House Bill 781 as amended by House Committee Substitute 1.
Question before the body is passage of House Bill 781 as amended by House Committee Substitute 1. Is there any discussion? Chair recognizes the gentleman from Carter for discussion of the matter. Chair recognizes the lady from Jefferson 41 for discussion of the matter.
Thank you, Mr. Speaker. Would the gentleman yield to a question?
He will yield.
Thank you, Mr. Speaker. Gentlemen, so it's 100% federal matching funds, is what I understood. And you said it will be all private matching with private funds. Do you have any idea how much we will be able to access or where that private money will come from? Is there a holding area for a government entity or something?
Gentleman from Jessamine.
So that is the point of the working group, to really figure that out. What the program allows on the federal level is to use those matching funds to match what a private company may donate in terms of funding. And so the working group that we'll put together will figure all of that out in terms of where it goes, how much, all of those types of things.
Lady from Jefferson.
Thank you, Mr. Speaker. Thank you for that answer.
Chair recognizes the lady from Jefferson 38 for discussion of the matter.
Thank you, Mr. Speaker. Will the gentleman yield to a question?
He will yield.
Gentlemen, it's my understanding that H.R. 1 from the federal government with SNAP education had eliminated the nutrition education component. So I guess my question today is, would our employment training rules under the USDA allow this to be an allowable use of the funds?
Gentleman from Jessamine.
Yes, it would, because what you'll see here in just a second, we are changing the title on this, so it does not fall under the SNAP education program.
Lady from Jefferson.
That's all, Mr. Speaker. Thank you.
Question before the body is passage of House Bill 781 as amended by House Committee Substitute 1. Clerk will sound the chimes. Those in favor vote aye. Those opposed, nay. Roll call is open for your vote. Have all members voted? Does any member wish to change or explain their vote? Clerk will take the roll. Being 95 members voting aye, no members voting nay, House Bill 781 as amended by House Committee Substitute 1 is passed. Gentleman from Jessamine.
Would you please have the clerk report House Committee Amendment 1, the title amendment?
Clerk, please report.
House Committee Amendment 1, the title amendment to House Bill 781.
Gentleman from Jessamine.
I move for adoption.
Without objection, so ordered. Gentleman from Jessamine.
I move the clincher.
Without objection, so ordered. Gentleman from McCracken.
Mr. Speaker, I move you, sir, that Senate Bill 199 be taken from its place in the orders of the day, read for a third time by title and sponsor only, and placed upon its passage.
Motion's made and seconded that Senate Bill 199 be taken from its place in the orders of the day, read for the third time by title and sponsor only, and placed upon its passage. Clerk, please report.
Senate Bill 199, an act relating to pesticide labeling. Senator Howe.
Gentleman from McCracken.
Mr. Speaker, I yield to the gentleman from LaRue for explanation of the bill and motion thereon.
Chair recognizes the gentleman from LaRue for explanation of the bill and a motion thereon.
Thank you, Mr. Speaker. You know, in my mind, Senate Bill 199 is a very simple bill. All it simply does is it says that the EPA controls all labeling on all pesticides, and this bill establishes the EPA-approved label is satisfying a manufacturer's duty to warn in a failure to warn lawsuit. I'm afraid there's a few that may disagree with my thought on this, so with that, I've decided to pull forth what I consider to be the only friendly amendment on this, and that is Floor Amendment 4. So I'd ask you please have the clerk report Floor Amendment 4.
Clerk, please report.
House Floor Amendment 4 to Senate Bill 199.
Gentleman from LaRue.
Thank you, Mr. Speaker. This floor amendment simply limits this bill's effect to only products that have an agriculture use requirement label. And I would move adoption.
Motion is for the adoption of House Floor Amendment 4. Is there any discussion of the floor amendment? Seeing none, those in favor signify by voting aye.
Aye.
Those opposed, nay. House Floor Amendment 4 is adopted. Gentleman from LaRue.
Thank you, Mr. Speaker. Like I said, this is a very simple bill that limits only to agricultural products that have an agriculture use requirement label. So I would move the adoption of Senate Bill 199 as amended by Floor Amendment 4.
Question before the body is passage of Senate Bill 199 as amended by House Floor Amendment 4. Is there any discussion? Chair recognizes the lady from Jefferson 43 for discussion in the matter.
Will the gentleman yield to a question?
He will yield.
Gentlemen, you said the effect of House Floor Amendment 4 was to limit the labeling to only agricultural products. Am I correct that the pesticides that have an EPA-approved label are still available to be purchased by consumers?
Gentleman from LaRue.
Yes, ma'am. There would probably be certain products that have an EPA agriculture label that a consumer could walk in and purchase at a store.
Lady from Jefferson 43.
Will he yield to another question?
He will yield.
So the amendment offers no additional protection for the non-agricultural user, like the home gardener, landscaping at your house. It offers no additional protection to everyday working families.
Gentleman from LaRue.
What this amendment does is protect products that are used in an agricultural, with an agricultural label. I would think some of those products would be available to be used in a homeowner's garden to grow food.
Lady from Jefferson 43.
Will yield to a question?
He will yield.
So even with the House Floor Amendment 4, the warning labels are not required to contain any cautionary statements concerning chronic risks, such as leukemia. The labels don't have to talk about lymphoma or other cancers. So my question is, are these going to be on the labels, or are they excluded, the risk against chronic diseases?
Gentleman from the row.
Mr. Speaker, you know, I think you have to think about this in a way that, and you have to look at specific examples. And I would say that for over 50 years, the EPA has found glyphosate in this example to be non-carcinogenic. If you look at California several years ago, they passed Proposition 65 just to require late warning labels to be placed on their products that would say such things. The problem is the California federal court struck down this effort because they found that a warning label that said glyphosate may cause cancer to be false and misleading. So I think that could be applied in this situation, that if we can't make assumptions, we have to go by real life scientific based research.
Lady from Jefferson.
Will the gentleman yield to a question?
He will yield.
So, as I understand it, the answer is the products will not be labeled. They will not tell consumers that if you use this product, you could get any of these cancers. And at the same time, can you explain to me why we're taking away their right to sue, but not warning them on the label, by the label, of the possible diseases that can come from using the product?
Gentleman from LaRue.
May I yield to the gentleman from Jefferson?
Chair recognizes the gentleman from Jefferson 33.
Thank you, Mr. Speaker. I want to answer that question if I could, and the one before. So if it's for agriculture, it's up to the EPA. So the answer is not no. The question was, will there not be a label if there's extra problems? The answer is not no. The answer is, if it's for agricultural purposes, that's up to the EPA. What the amendment does is it takes away the effect of this bill on all things that aren't agricultural use. So if it's not agricultural use, no change in the law. If it's agricultural use, then we're leaving that up to the EPA. So we can't say categorically that they won't be on there or they will be on there. But there will be the federal EPA that takes a look at that product and the labels and determines for all of the nation what needs to be on the label. So it's not a yes or no across the board answer. It's a case-by-case thing, but the EPA will be making that determination.
Lady from Jefferson 43.
And if I could just ask one final question from the gentleman that...
He will yield.
So under your explanation, it still is that the working families and consumers will still be at risk, depending on whether or not the EPA puts a label warning them that they could get these diseases. And it would depend on the EPA, and it could be there, it could not be there. And
gentleman from Jefferson 33.
So if it's an agricultural product, the Environmental Protection Agency, which we rely on across the country, will make the determination as to what needs to be on the label across the country. And I believe and hope that they will do the right thing in each of these particular drugs, each of these particular pesticides. So the Environmental Protection Agency, which we rely on across the country, will make that determination. So you can't say that they're not going to be on these labels, because we don't know that. We don't know that because each of these pesticides will be reviewed by the EPA with a decision on what has to be on the label.
Lady from Jefferson 43.
final question, sir. Will he yield?
He will yield.
Is there anything in this amendment or in this bill that makes a recommendation to the EPA that Kentucky thinks consumers should be warned about the dangers of pesticides at all available opportunities?
Gentleman from Jefferson 33.
I would think that that's the mission of the EPA. I mean, when the EPA was created, it was to protect our people. And if they need to hear from Kentucky that we believe that they should follow their mission, we'll say it here today, we'll say it loud and proud, we'll say it all the time. That is the mission of the EPA. And so again, what this amendment does is if it's an agriculture product, the label will be decided by the Environmental Protection Agency, which we rely on across the nation.
Lady from Jefferson 43.
Thank you.
Chair recognizes the lady from Jefferson 41 for discussion of the matter.
Thank you, Mr. Speaker. May I ask a question? And maybe speak on the bill. Thank you, Mr. Speaker. Gentlemen, where are you? There you are. So this would affect mainly one manufacturer, is that correct, Bayer? Or other manufacturers as well?
Gentleman from Lurie.
Thank you, Mr. Speaker. This bill, as amended, would affect only products that have an agriculture use requirement label.
Lady from Jefferson 41.
Can I have a follow-up?
He will yield.
Thank you. So who would the manufacturer be of most of those products?
Gentleman from Lurie.
It's kind of, I mean, I don't know how much time we've got here that I'm afraid, like you like to say, I'm afraid the speaker would hit his gavel on me if I started mentioning all the companies that this could work with.
Lady from Jefferson.
Thank you, Mr. Speaker. May I speak on the bill?
Yes, ma'am.
Thank you, Mr. Speaker. So there are probably several manufacturers that are behind this piece of legislation to limit your neighbors and your friends and your families from getting judicial redress, getting compensated if they should get a lymphoma, a cancer, something that's going to put them on chemotherapy and radiation, and probably in the long run kill them from these products. So these manufacturers, of course, want you to be able to not be able to look for redress within Kentucky. I was a nurse for many, many years, and I dealt with lots of folks going through chemo, through radiation, directly related to some of these products. Some were farm workers, some were farmers. One person worked out in a field of tobacco in western Kentucky. And it was heartbreaking to see those folks coming in for new accesses for their chemo, to see them have to go undergo radiation, which caused radiation burns, and then ultimately have to plan for their funerals. And these were children that maybe played in the fields, maybe got a hold of the products, and to not be able to look at the manufacturer, which could be 50,000 products, mainly from foreign interests from China. So we're protecting manufacturers that may be sending stuff over from China, which we don't know what's in it half the time. I think it's a huge mistake to vote for this bill. And also, I think if you look at your Kentucky Constitution and the sections that say you have a right to a jury trial, you have it, let me put on my glasses so I can see what I'm looking at, but right of judicial remedy, section 14. This will surely go to court. Section 54, no restrictions on recovery for injury or death. There's another section. 241 of your Kentucky Constitution, recovery for wrongful death. I won't read the whole thing, but I would seem that this is in direct conflict with our Kentucky Constitution. And I can guarantee you all this will be headed to the court system in Kentucky and end up costing our taxpayers, costing us all a lot of money. Not to mention the significant cancers and unnecessary chemo and death of your families and your friends and your neighbors and your constituents. So I would urge you to vote no on this piece of legislation. Thank you, Mr. Speaker.
Chair recognizes the lady from Fayette 75 for discussion of the matter.
Thank you, Mr. Speaker. Will the gentleman yield to a question?
Y'all are welcome to talk back and forth. He will yield.
Thank you. I would like to start by remarking that the gentleman has been exceedingly friendly in answering many questions. And I'm very grateful that he's my seatmate. My question for you, gentlemen, is this. Does the EPA issue warnings about every conceivable health hazard that could happen?
Gentleman from the room.
No, they do not. However, if you have, the way the EPA works, if you have a claim and you have good enough research to back it up, they work just like FDA or many other government agencies, and they can put a stop on those products immediately if they choose to.
Lady from Fayette 75.
Thank you, gentlemen, for that answer. I am concerned about may I speak on the bill, sir?
Yes, ma'am.
Thank you. I am concerned about the period of time between when somebody in Kentucky starts to realize that they've had a health issue based on a product that was labeled but failed to capture what they're experiencing. And I do believe in the EPA, and that once there's a class of those people, the label will be updated. But for me, one Kentucky family losing a loved one is too many. And so that's why I've proposed House Floor Amendment 5. It was filed today, and so, Mr. Speaker, I'd ask to suspend the rules to consider House Floor Amendment 5 and request a vote on that, sir.
Motion of the lady from Fayette 75 is for suspension of the rules for the purpose of allowing action on House Floor Amendment 5, which was just filed today. Motion is non-debatable, requires a constitutional majority to suspend the rules. Constitutional majority of 51 to suspend the rules. Those in favor of suspension of the rules vote aye. Roll call is open for your vote. Have all members in favor of suspension of the rules cast an aye vote? Clerk will take the roll. 18 members voting aye. Motion to suspend the rules fails. Lady from Fayette 75, the floor is still yours.
Thank you, Mr. Speaker. There are several problems with the bill as I see it. And one of the most glaring to me is that scenario that I was laying out, that as drafted, this bill fails to take account of families that will be injured irreparably or people who will die from things that don't currently require an EPA label. So, as drafted, this bill prevents those families from recovering even when they can prove that that injury happened. That to me is exceedingly troublesome. And I would be willing to entertain this bill if certain changes were made, but it doesn't seem like we're going to do that. And because Kentuckians deserve full information, because they deserve their right to trial, because they deserve to collect when their family is harmed, I have to be a no.
Chair recognizes the gentleman from Carter for discussion of the matter.
Thank you, Mr. Speaker. Permission to speak on the bill.
Yes, sir.
First, I'd like to compliment the gentleman from LaRue on the floor amendment. I know there's been a lot of heartburn and concern. I think he took a bill that many people were likely a no or pass vote on and is giving something that people can get more supportive of. So I would like to thank him for that. I think it makes it much improved. Want to do what I can to amplify, I think, what we're dealing with here. So when you're dealing with product liability cases, there are essentially two causes of action. You have a defective product, which that's not really what these cases are. They are what's called a failure to warn, which is the second type of product liability case. I think the main reason for the floor amendment that was adopted was under the original version, Arguably, this would have affected pesticides, which is a very broad category. It's not just agrochemicals. It has a very broad definition under these rules. It would apply to many household chemicals as it was received in this body, in my opinion. Items potentially like Lysol, Clorox, pool chemicals. What this floor amendment that was adopted, what it does is it would not affect those. It would only be for the agricultural label. I think that's a very important distinction. I've also heard comments that it would prevent potential barring of suits. It would be my opinion that anyone that had exposure to these chemicals, even if it's an agricultural product that would be considered a pesticide under this, if that exposure took place prior to the enactment of this law, if this were to pass, I think absolutely those persons afflicted by any sort of cancer would absolutely have the opportunity to have a failure to warn claim. I would argue moving forward, if this were to go into effect, that might be something that person may have more difficult time doing because of there's arguably not a failure to warn. So I just want to take the opportunity to try to amplify that. I know this is kind of nuanced and complex, but wanted to take the time to also thank the gentleman from LaRue for bringing this. I think he took a bill that people had a lot of concern about and is getting this to a point to where potentially we can do something to help farmers who care obviously very much about this. Kind of reminded of the Paul Harvey monologue. We need to be very mindful of farmers, and I know farmers get a little excited. They are always seeking better days through better ways, and they have that inborn fondness, like the FFA creed says. So I know this is a very emotional topic, but I just wanted to take the time to thank him for this floor amendment and make an effort to try to clarify what this bill with the adopted floor amendment actually does. Thank you.
Chair recognizes the gentleman from Christian 9 for discussion of the matter.
Thank you, Mr. Speaker. Question of the sponsor.
He will yield.
Gentleman from LaRue, is there anything in the language of this legislation that will take away the right of any member of this body or any citizen of the state of Kentucky to sue one of these manufacturers in the event they became sick and it was possible from use of a product?
Gentleman from LaRue.
I'm going to use a word here that's been thrown around a whole lot, Mr. Speaker, and that's immunity. And this does not give immunity to these companies. In fact, we can claw back a failure to warn claim if a smoking gun is discovered and it expressly preserves every other cause of action. And I want to be clear to this body. As a person who uses these products on a daily basis, if I ever discover that one of them has made me sick, my family sick, my employees sick, I can guarantee you I'm going to be going after someone, but I have to be able to prove that. You know, we're not giving anyone immunity here. We're just saying we're going to follow the label to the letter of the law.
Gentleman from Christian.
Thank you, Mr. Speaker, and thank you, gentlemen from LaRue. For myself personally, I want to thank the gentleman from LaRue, the gentleman from Jefferson, for what you've put together to bring this legislation forward. I would dare say there's probably only a handful of the members of this body that have actually ever held an applicator license to apply these products. I am one. I dare say there's probably only a handful of this body that have actually ever worked in a ag retail store that have sold these products. I am one. For those that may be nervous of a product listed, share with you some that you probably have used on a garden that is sold in one of these ag retail stores. 7-Dust, used for insecticide. 7-Dust used for insecticide upon your garden is sold, and it's used by our farmers in agriculture and sometimes. Fungicides, 2,4-D to spray for brush around your yard. Roundup itself that is used to spray around the edges of your homes, your fences, around the edges of your house so that you don't have to weed eat as often. These are all products that are sold that our farmers use and that the general public have access to. One of the things that I have learned when selling the products, when using the products, there is a warning on the label. It's very distinctive. It's in large letters. And it tells you to read the directions. And they're specific. I understand the importance of what we are doing here, because if we don't, the possibility of some of these products moving, not being able to be available there to our farmers. And I dare say there's any of us that would want to see us go back to the days, and we're not talking that far back, of 40, 50 years ago, when some of these weren't available. Currently, we see yields of crop to feed our country on a tremendous amount of less acres than compared to 50 years ago. So I'm very happy to see us moving this legislation forward. We need it for agriculture, but once again, I want to remind everyone, with this legislation, we're not taking away, no one is taking away the ability of an individual to sue. We're not giving these companies immunity if something was to make an individual sick. We're just making sure that access is there to be able to use this, in particular in our ag community. Thank you, Mr. Speaker.
Chair recognizes the gentleman from Campbell, 67, for discussion of the matter.
Thank you, Mr. Speaker. May I ask the gentleman from LaRue a question, please?
He will yield.
Just with the bill as in Amendment 4, what exactly is a master label? Could you explain that?
Gentleman from LaRue.
In the process, thank you, Mr. Speaker, in the process of a chemical company, in this instance, going forth to register a new product, that is a reference word they use where they have to select it to be used for agriculture on their application.
Gentleman from Campbell.
Sure. May I ask a follow-up question?
He will yield.
Yeah. Thank you for that. Maybe can you just talk about what specific issue we're trying to solve with this bill? Is this about the cost of pesticides and insecticides? Are we trying to reduce costs to the companies that manufacture them? I'm trying to understand what is behind this and what practical outcome do we expect to see in stores or to farmers in Kentucky?
Gentleman from LaRue.
Thank you, Mr. Speaker. You know, I think you hit the nail on the head when you said cost. We've had a lot of these lawsuits in the past that have gone against a lot of these companies. You know, I sit here and listen to this body in this chamber all the time talk about that we want to draw companies in to invest in Kentucky. We want to draw companies in to invest in our district. We want them to bring jobs. But we never are willing to stand up and say, hey, we can't help you from having frivolous lawsuits brought against you that may in turn hurt you financially. Now, I think you can look at this instance with the lawsuits that have been filed. Obviously, that's not coming out of, that money's not coming out of the clouds. It comes from somewhere. So it is already, in my opinion, driving up the cost of products to farmers in this state.
Gentleman from Campbell.
May I speak briefly on this bill, please?
Yes, sir.
And yeah, I do want to acknowledge, I mean, I think House Amendment 4 definitely makes this a much, much better bill. I mean, I will still be voting no. I will point out, I look at the Federal Insecticide, Fungicide, and Rodenticide Act. There is no mention of master label in that entire act. I don't know if, I don't actually know what that means, and I'm a little worried about that word, master label, in this bill. It's not defined in Kentucky statute either. And you know, I'm all for reducing the cost of food and reducing the cost of, you know, the cost of running farms and producing food. I don't see enough data out there that, you know, when certain companies have illegally marketed their products or have not done the research. See, and this is, I think, how you get around these issues, especially with the EPA. So, for example, if you're making a food or drug, especially a drug, you have to do studies to prove the safety and efficacy. The EPA doesn't require this. I mean, the EPA, you know, so if you don't do the studies, you can stick your head in the sand and act like you don't know the risks. And that's how you can get these things labeled. We have had experiences with this in the past with different pesticides. I don't know if anyone here has used paraquat, which is one of the most dangerous chemicals used in agriculture. It's so limited now, but for a long time it wasn't limited because they just didn't do the studies. And I'm not clear that this approach is really going to save us any money. I don't see how this is really going to bring food prices down, but I do see this as potentially increasing the risk of health to Kentucky, and so I'll be voting no. Thank you.
Chair recognizes the gentleman from McCracken.
Mr. Speaker, I believe that to live and work on a good farm or to be engaged in other agricultural pursuits is pleasant as well as challenging, for I know the joys and discomforts of agricultural life and hold an inborn fondness for those associations which, even in hours of discouragement, I cannot deny. That's my favorite paragraph from the FFA Creed. This bill gives me heartburn, but not for the reasons that it's given you guys heartburn. It gives me heartburn because all my life we have been taught to fear the EPA. They're trying to run farmers out of business. We are desperate in agriculture right now. We just want to have the products that we need to feed you. They've taken so many wonderful products off the market. DDT. Boy, we saved the bald eagles. Who cares that malaria outbreaks killed so many people after we took DDT off the market? It was a wonderful insecticide. I wish we had it back. Folks, many of you wish that the farmers of Kentucky and the farmers of America had to farm like it was 1920 all over again. Meanwhile, the farmers that I know that are heroes who are begging for this legislation are saying, just give me a fighting chance. We want to feed you. We want to feed America. We want to feed the world. Folks, give them the tools they need. This is common sense legislation. Don't let runaway juries and all the craziness that rules the day sometimes in the People's Republic of California come to Kentucky. Folks, in the ag business, my number one way to sell a pesticide is to say this. Read the label, and it says here clearly, you can't buy this in California. And I'm going to tell you, that's the fastest sellers. They're like, oh, it must work if you can't sell it in California. This is common sense legislation. I applaud the senator from Callaway for bringing it. I applaud the gentleman from LaRue for carrying it. Let's pass this common sense legislation and move on to the next bill.
Chair recognizes the gentleman from Fayette, 45, for discussion of the matter.
Thank you, Mr. Speaker. The gentleman yield to a question.
He will yield.
It's my understanding that this largely deals with a failure to warn as kind of a lot of the things that are being changed in this legislation, gentlemen. The case Johnson v. Monsanto was decided in 2018, and that was a failure to warn lawsuit, in which case a jury trial resulted in compelling Monsanto to pay $289 million in damages due to causing non-Hodgkin lymphoma in Dwayne Johnson, the plaintiff. If this bill is passed, and Dwayne Johnson were to live here in the Commonwealth of Kentucky, would he be unable to bring such a failure to warn lawsuit in this state?
Gentleman from LaRue.
I don't know Dwayne Johnson. I guess he is The Rock. I've seen him on TV a lot, whether that's the same Dwayne Johnson or not. But, you know, I'd also tell you I'm not a lawyer. I don't know if one of my other friends wants to chime in on this, but the way I see this, if they can prove that they have been negatively impacted by this product and they have a smoking gun, they still have a case to go after.
Gentleman from Fayette.
Thank you. I wish to speak on the bill, Mr.
Yes,
Speaker.
sir.
Thank you so much. As my friend said, and proponents of Senate Bill 199 have said, this bill is not a shield and doesn't stopping us from going after a company who maybe is hiding information. But that is a legal fiction. Because the way the law works is you find out if a company is hiding something during the discovery phase. And that's actually when the Monsanto papers came out of the Johnson v. Monsanto case. That's when a judge orders the corporation to turn over their internal emails, their secret memos, their suppressed lab results. But Senate Bill 199 would then kill this case before it even gets to discovery by deeming that the EPA label by itself is sufficient as a matter of law. Then this bill forces a judge's hand to dismiss the case at the very start. You can't prove that they're hiding the truth if this law slams the door shut before you're even allowed to look behind it. It's a catch-22 designed by corporate lobbyists that you can sue them if you have proof, but it makes it impossible or illegal to find that proof. Let's look at the facts. Kentucky is number 1 in the nation for cancer incidence. We are number 1 in the nation for cancer mortality. We sit in this chamber while our neighbors are being diagnosed with life-altering illnesses at a rate literally higher than anywhere else in America. Now, to the claim that there is no research showing that these chemicals are dangerous, I would say look at that case in 2018, a case that was won by Robert F. Kennedy Jr. Now, friends who identify with the Make America Healthy Again movement, RFK Jr. is a hero precisely of that movement because he fought to expose these corporate secrets. He showed that the EPA labels are often decades behind the science because corporations themselves are ghostwriting the studies that the EPA relies on. If Senate Bill 199 had been the law in 2018, the truth about glyphosate would still be buried in a filing cabinet in a corporation's basement. And who are we protecting with this forced silence? We're shielding companies for products whose raw active ingredients are overwhelmingly sourced from China and being asked to sell out the health of Kentucky's children for the legal rights of our farmers just to protect the bottom lines of companies importing these chemicals from overseas. We cannot make America healthy again if we make it illegal to hold the people making us sick accountable. Kentucky leads the nation in cancer. We should be leading the way in consumer protection, not leading the way in corporate immunity. I encourage you to vote no on Senate Bill 199.
Chair recognizes the lady from Fayette 93 for discussion of the matter.
Thank you, Mr. Speaker. May I speak on the bill?
Yes, ma'am.
Thank you. I just want to first I want to start by making a point of clarification. I did a quick little Google search while we're sitting here. There is no known effort by the maker of Roundup, the parent company being Bayer. There's no effort to relocate their headquarters or their manufacturing location anywhere other than where it is right now. So what we're discussing here will have no impact on whether or not we're attracting that company to come to Kentucky. But this bill, SB 199, does grant sweeping legal immunity to pesticide manufacturers. That includes the maker of Roundup. Even when a Kentuckian develops cancer after years of exposure to their product, at its core, this bill closes the courthouse doors to our citizens before they ever get the chance to present their case. That's deeply wrong. And as my friend from Fayette 45 just said, Kentucky has the highest rate of new cancer cases and the highest rate of cancer deaths in the country. Every single one of us represents families who have sat with a loved one through the diagnosis, through the fear, the treatments, the uncertainty, and sadly the goodbyes. In a state that is already carrying such a heavy burden, the last thing we should be doing is making it more difficult for our people to seek justice when a product harms them. In committee, members were told to trust the federal government to determine what's safe. But history has shown us that federal approval of labeling does not always mean that the label is as safe as we have been led to believe. Consider OxyContin. When Purdue Pharma introduced it, the government allowed labeling suggesting it was less addictive than other opioids, and that claim stayed on the label for years. That drug was widely prescribed, and patients believed that it was perfectly safe. But by the time the stronger warnings were discovered, Kentucky was already in crisis, ground zero for the opioid epidemic. So we, as Kentuckians, we know exactly what happens when we trust a label and stop asking questions. So when the sponsor of the bill says the EP label is enough, I want folks to understand the science is not settled. The label is not enough, and the courts have agreed. Juries across the United States have been hearing the evidence, including the increased rates of non-Hodgkin lymphoma associated with the use of products like Roundup that contain chemicals like glyphosate, and they have been returning multi-billion-dollar verdicts in other states like Missouri, Pennsylvania, Georgia, and our neighbors to the south in Tennessee. In total, the manufacturer has already paid over $10 billion to resolve claims and still faces more than 67,000 active lawsuits. And just this month, a federal judge granted a preliminary approval for a new $7.25 billion settlement. There's something wrong with the product, and we deserve to be told what it is. These are not frivolous lawsuits. These are ordinary people. They are farmers, they are landscapers, and they are homeowners who trusted a label and got cancer. So now consider how this manufacturer has responded to these lawsuits. Rather than reformulating the product or adding stronger warnings, they have lobbied state legislatures across the country to pass exactly what we are being asked to vote on today. Legislation that makes the EPA label an ironclad legal shield. The company has publicly acknowledged that if courts rule that federal labels preempt state warning claims, it would, in their words, largely foreclose present and future claims. So for those watching at home, that's an admission straight from the company. They're not hiding what this legislation does. They've openly said it will kill the litigation that has cost them billions. This bill does for them in Frankfurt what they have been unable to do in courtrooms across the country. The company behind this bill is using us to accomplish legislatively what they have been unable to accomplish in court. I don't know about anybody else, but I'm nobody's puppet. Our courts exist precisely so that evidence can be heard and justice can be pursued outside of the regulatory process, free from industry influence. This bill eliminates that option for Kentuckians, the very people we were sent here to represent. A farm worker in western Kentucky who develops non-Hodgkin lymphoma after years of Roundup exposure would have no path for justice in our courts. And meanwhile, that same person could win a verdict in almost every other state in the country. SB 199 would make Kentucky a safe harbor for the very companies causing harm. And while our neighbors, our farmers, and our families suffer the unbearable cost, we are the last line of defense for our people. When Kentuckians are harmed, they deserve their day in court. This bill takes that away. And so for those reasons, I will be voting no on SB 199, and I urge every member in this chamber to do the same. Thank you, Mr. Speaker.
Chair recognizes the lady from Fayette 76.
Thank you, Mr. Speaker. May I speak on the bill, please?
May proceed.
Thank you. I definitely don't look the part, but I am also a sixth-generation Kentucky farmer. We use no-till farming on our farm for all of the benefits that you all know and have heard about throughout these debates. It lets us keep more nutrients in the soil, helps limit the amount of erosion, and throughout all of this, I actually learned that that originated in Kentucky, which is pretty cool. Christian County, no less. One of my earliest memories was walking through the tobacco fields in Woodford County with my parents. And tobacco, for all of its ills that we now know, is a really beautiful plant. I reached out to touch it as a little girl, and my father really quickly grabbed me away from it. There were bugs and fungus and all these nasty things that a little girl didn't want to touch. But my father looked at the plant and said, it's dangerous. The bugs and the fungus that are on there, that's dangerous too. But the worst of all is the chemicals that are on it. He went on to say that yes, these were dangerous, but they were also a necessary part of our crop production. And I share that story with you all because I understand the need for these products to manage the weeds, the insects, and the fungus growth. I understand the benefits for the crop yield, and I understand the fear that many farmers have that the glyphosate they depend on might not be available or affordable. But I also believe that our farmers and our consumers need to know that there may be a risk. We don't know that for sure, but how do we think that there might be a risk? Because Bayer, the parent company of Roundup, has settled nearly $20 billion in lawsuits over the past few years. $20 billion. That's a lot of money to dole out if you don't think you've done anything wrong, even if you're a company that makes $50 billion a year. So Bayer tells our farmers that they're not going to be able to keep doing business here because of these lawsuits, that they're not going to be able to sell them the products that our farmers need. That's out of one side of their mouths. On the other side, as recently as 2 weeks ago, they told their shareholders, their investors, that they are committed to maintaining a 40% market share of glyphosate in the United States, regardless of the lawsuits, of the tariffs, and the regulations that they are facing because of the imports from China. So it seems like the company is talking out of both sides of their mouths, one to farmers and one to their investors. Where's the disconnect? And the answer to that right now is that I don't know. The EPA doesn't know. We haven't done the research on it yet. But there is enough of a disconnect for me that I think we need to wait and see where the truth is. We know throughout history that corporations can't be trusted to do the right thing by the consumers. We had cigarette companies who for decades told us that they didn't cause cancer, and that they weren't marketing to children. They were. The Sackler family and Purdue Pharma claimed for years that they weren't intentionally trying to get people addicted to opioids. They were. It takes decades of scientific research before the federal government can make a definitive declaration on this. Our farmers don't have that time. Every year that we wait without changing our labeling is another year that Bayer is making more money and our farmers are getting sicker. Our farmers in Kentucky already have significantly higher rates of cancer than the average Kentuckian. Is that correlation or causation? I don't know that either. But we need more time to study that before I feel comfortable enough to grant a legal immunity. And I understand that some people in this body feel that this bill would not grant a legal immunity for Bayer or other pesticide companies. Every attorney that I have talked to outside of those on this floor think that it would. So what I know is that our farmers care about the future of our land and about their families. And I'm very concerned that this bill could lead for many more of them to not be able to be here with us to enjoy that future. So I urge you to please not pass this legislation, at least until we have more information about the real effects of the products. Thank you.
Chair recognizes the lady from Davis 7.
May I speak on the measure?
Yes, ma'am.
Well, I have to say, I think Chicken Little's been busy today on this floor. Google's been busy, and it's been interesting to hear the different dynamics. But I can tell you from a farm child we sold farm chemicals my entire life. Long generation, long longevity in our families. Length of living from these chemicals, these herbicides, these pesticides, and all in the name of feeding the world. I have to agree, the gentleman from McCracken, we talk about it. We wouldn't want our life any other different than where we've been in our path on our journey. But I think it's interesting today of all the dots that have tried to be connected. Just let me name a few. The gentleman from Jefferson 93, she wants to connect it to pharmaceuticals. We're not talking about pharmaceuticals today. And I can tell you it takes less time to get a pharmaceutical on the market for you to take an Excedrin for your headache or take Sudafed for your cold or whatever that may be. The herbicides and pesticides, fungicides, all those take much longer. And you want to know why? The reason is for the safety, because it goes on your foods. It goes on the products that you put in your body for the nutrition for your body. I thought when this came up, I started looking at a couple different things. Randomly, I started looking at different labels. My toothpaste. Guess what my toothpaste says? Do not use excessive amounts. If you swallow excessive amounts, seek medical advice immediately. I never thought about eating a tube of toothpaste, but I'm sure y'all have had a child or two that has. But if they did you rush them to the emergency room? You may have needed to. But if you didn't, is it on you that you didn't follow the label directions? And that's what we're talking about today. Follow the directions. Simply follow the directions. Lady from Jefferson, I will tell you, don't ever drink any of the chemicals that have the labels, warnings on them. Use, follow by the directions. You know, we could say the lady from Fayette 76. She's got dye in her green jacket. That may cause something down the road. We don't know. But we're hoping that all the tests that go about any and every product that we use, that we eat, that we touch, that we expose our families and loved ones to, that they're safe. We have a tremendous amount of burden that we employ on these people to do the testings. There is not one single person I can believe that works for a chemical company, a pharmaceutical, or anything that wants any harm intentionally to come to anybody. But believe it or not, there's maybe a few attorneys out there that may exploit people and opportunities way beyond the means of anything that we could reasonably expect. So I think it's interesting for all the different Chicken Little conversations we've had today. And also a reminder of it always amazes me how disingenuous it is of wanting to suspend the rules for an amendment. They're going to make it better, but they're still not going to vote for it. That always amazes me, how we go down that path. The gentleman has in good faith worked with people to come up with an amendment that satisfies the majority of the people in this room. And we appreciate that, and that's what it's all about, of coming to the majority to make sure that we can pass legislation that's for the benefit of our Commonwealth. And we appreciate that, and we applaud you for that. But just kind of keep in mind, follow the label directions. If you don't want to farm, don't farm. But please thank a farmer for feeding you and doing everything they can to use all the resources they have to do the very best they can to keep you safe, to provide nutrition for you, and make your life a better place. Please vote for this Senate Bill 199. Thank you.
Question before the body is passage of Senate Bill 199 as amended by House Floor Amendment 4. Clerk will sound the chimes. Those in favor vote aye. Those opposed, nay. Roll call is open for your vote. Chair recognizes the lady from Scott 88 for explanation of vote not to exceed 2 minutes.
Thank you, Mr. Speaker. When I think of the magnitude of Senate Bill 199 and its impacts on my suburban agricultural community, I can't help but think of Jim Coleman, an organic farmer in my district who runs Coleman Crest Farm. Maintaining the existing legal standards would not eliminate access to crop protection tools essential to Kentucky agriculture. Rather, I believe it would preserve a balanced system of accountability that supports both agricultural productivity and public confidence. I voted no today to protect individuals who reside near agricultural operations, farm-adjacent workers, visitors, or rural community members, and others who could face substantial barriers to pursuing legitimate claims. Senate Bill 199 sacrifices the health protections afforded to Kentucky residents to the interests of agricultural chemical manufacturers. Thank you.
Chair recognizes the lady from Jefferson 41 for explanation of vote not to exceed 1 minute.
Thank you, Mr. Speaker. I voted no on this bill today because it is going to make billionaires even richer, probably from China, Bayer, and their manufacturers in East Asia. And yes, we can worry about the farmers, but there's many reasons that we need to worry. Weather, yes, climate change. Other countries won't buy their stuff. They can't find workers. I saw on the news the other day. They're having trouble getting their crops picked. And tariffs are really hurting them too. But this bill is going to shield people, your neighbors, from being able to go to court. And I think this bill, hopefully it will not make it through the Senate, but I think we really should think twice before we vote yes on this bill. Thank you, Mr. Speaker.
Chair recognizes the gentleman from Boyle for explanation of vote not to exceed 2 minutes.
Thank you, Mr. Speaker. I'm voting yes today, and there's probably no stronger supporter of the Seventh Amendment right to a jury trial than I am on this floor. But I want to thank my friend from LaRue for the amendment. I met with farmers from my district last week from Kentucky Farm Bureau, and they advised me that if they lost this product, glyphosate, which is a mouthful, if they lost that product from the market, that they would lose probably 70% of their crop production. And that would take us back to the 1940s in terms of where we were in our agriculture. So it would have a devastating effect upon our farmers. And so this is an important bill to those folks who I represent a lot of farmers. It's an important bill to them. So I'm going to stand with them today and vote yes. And this application, the application of this bill is only to agricultural products. So with that limited application, Mr. Speaker, I'm voting yes and glad to see that it's going to pass.
Chair recognizes the lady from Graves for explanation of vote.
Thank you. Agriculture is a $48 billion industry in Kentucky, contributing $8 billion in product. Farmers put food on the table for all of us. And no one in this room undervalues the contribution of farmers to our Commonwealth or wants them to operate without the tools they need to continue their farming operations efficiently and effectively. My own family farms, we use pesticides. We spent approximately $20,000 on glyphosate alone in 2025. I know firsthand how difficult farming is, how tight the margins are, and how it feels to want to throw in the towel every year. But this bill is not about farming. Passage of this bill without the amendment would have effectively shielded nearly 60,000 chemicals that all Kentuckians use daily from liability to injury if the EPA says those chemicals do not cause harm, instead of leaving our courts to consider all available evidence when making a determination. I want to call attention to another frequently used chemical on our Kentucky farms. Atrazine is an herbicide used in corn production. It is sold by multiple manufacturers under several brand names as well as in generic form. Atrazine is also regulated by the EPA and is one of the thousands that we would vicariously shield from liability. Multiple peer-reviewed studies, including the Agricultural Health Study of 2020, has linked long-term exposure to atrazine to clear cell renal carcinoma in farmers. We use atrazine on our own farm, and last September, my husband was diagnosed with stage 4 renal cell carcinoma. The formal reevaluation that all pesticides undergo under FIFRA takes place every 15 years. The most recent registration review for atrazine concluded in September 2020, and labels were most recently approved in 2021. In spite of sound and current evidence, the EPA considers atrazine not likely to be carcinogenic to humans. One final point that I would like to make is that the Supreme Court is set to decide on this labeling issue in June 2026, so I still question why we are even taking this up at this time. That said, this bill pains me significantly, but I believe the amendment makes the bill more palatable, and after digging my heels in to do what I could to make it better, I'm going to vote only on behalf of the farmers in my community who are desperate to have any level of control in the uncertainty of this industry. I believe we can continue to work on this issue to make sure that all consumers may be adequately warned of any potential harms pending the SCOTUS decision. It isn't that difficult to require transparent labeling at the state level. In addition, we need to work diligently to answer the question, why is it really so hard for farmers to continue in this industry, an industry upon which everyone depends? This legislation is a Band-Aid on a much more significant problem, and finding an answer and identifying real solutions will make all the difference in our farmers' ability to continue providing food for the entire world. Thank you.
Chair recognizes the gentleman from Carter for explanation of vote not to exceed 1 minute.
I'd like to explain my yes vote.
Yes, sir.
Without the floor amendment being adopted, I would have been a no on this, but I will be casting a vote today in favor of this. It is very limited in application for agricultural products, and it is my position, as well as many others, that if there's any exposure prior to the possible enactment of this bill into law, that there's absolutely still a cause of action on a failure to warn. So for those reasons, I will be voting aye. Thank you.
Chair recognizes the lady from Jefferson 34 for explanation of vote not to exceed 2 minutes.
Thank you, Mr. Speaker. I just wanted to explain my no vote and remind everybody in this chamber that science moves faster than federal regulations, and we shouldn't have to wait 10 years for the EPA to update a sticker before our citizens are protected. And what we're really doing here is that we are being asked to trust that a multi-billion-dollar industry will always be honest and that a stretched thin federal agency will always be right. That being said, I think it's important for people in this room and at home to know that the EPA has hit a 40-year low in staffing after Trump has targeted its public health experts in not only the first administration, but in this current administration. So when we are wrong about this bill and the effects that it could have, not only on our farmers, but on the parents and our neighbors who are out in their yards gardening, it will be our families who pay the price, and that will come in the form of the hospital bills and the lost loved ones. And for that reason, I will be a no today.
Chair recognizes the gentleman from Jessamine for explanation of vote not to exceed 2 minutes.
Thank you, Mr. Speaker. I would like to explain my no vote.
Sir.
I believe that we as a Commonwealth ought to be passing measures that make our citizens healthier. As the chair of the MAHA task force, I cannot in good conscience vote on a bill that I do not believe will do that. We ought to be fighting for our residents, fighting for our farmers at the same time, and fighting for the health of a Commonwealth that consistently lags behind the rest of the nation. We are number one in cancer in the United States. Number one. That's not where we want to be number one. And I believe it's important that we have to at some point begin to say that we are going to stand up and fight for the health of our citizens, and that's why I voted no. Thank you, Mr. Speaker.
Clerk will take the roll. Being 53 members voting aye, 37 members voting nay, House Bill 199 is amended by House Floor Amendment 4 is passed. Gentleman from LaRue.
Thank you, Mr. Speaker. I move the clincher.
Without objection, so ordered. Gentleman from Kraken.
Mr. Speaker, I yield to the Clerk of the Senate.
Chair recognizes the Clerk of the Senate.
Thank you, Mr. Speaker. The Senate has passed House Bill 1 with letter, the governor's veto notwithstanding, and is returning same to this honorable body.
Thank you, Madam Clerk.
Thank you, sir.
Chair recognizes the gentleman from Bullet 49, Chair of the Enrollment Committee, for an Enrollment Committee report.
Thank you, Mr. Speaker. The Enrollment Committee has met and found the following bill to be in order and ready for your signature. Senate Bill 183.
Thank you, Mr. Chairman.
Gentleman from McCracken.
Mr. Speaker, I move you, sir, that House Bill 236 be taken from its place in the orders of the day, read for a third time by title and sponsor only, and placed upon its passage.
Motion made, seconded, that House Bill 236 be taken from its place in the orders today, read for the third time by title and sponsor only, and placed upon the floor for its passage. Mr. Clerk, please report.
House Bill 236, an act relating to emergency management services. Representative Ballman.
Gentleman from McCracken.
Mr. Speaker, I yield to the gentleman from Jefferson 28 for explanation of the bill and motion thereon.
Chair recognizes the gentleman from Jefferson 28 for an explanation of the bill and motion thereon.
Thank you, Mr. Speaker. Would you please have the clerk report House Committee Substitute Number 1?
Mr. Clerk, please report.
House Committee Substitute 1 to House Bill 236.
Gentleman from Jefferson.
Mr. Speaker, I move adoption.
Motion made for the adoption of House Committee Substitute 1. Is there any discussion? Seeing none, all those in favor, please signify by saying aye. Aye. All opposed, nay. Motion carries. House Committee Substitute 1 is adopted. Gentleman from Jefferson.
Thank you, Mr. Speaker. Glad to follow that one up with a simple bill here that's simply going to move for-profit EMS training programs from dual governance currently under the KCPE and K-Beams under K-Beams by itself where it belongs. I certainly want to thank our chairman, the gentleman from Spencer, for ensuring all key stakeholders here got what they needed out of this policy change. He and his staff did a lot of due diligence on this that is greatly appreciated. And at this time, Mr. Speaker, I'd like to yield to the gentleman from Jefferson 33 for a friendly floor amendment.
Chair recognizes the gentleman from Jefferson 33.
Thank you, Mr. Speaker. I have the clerk report House Floor Amendment 1, please.
Mr. Clerk, please report.
House Floor Amendment 1 to House Bill 236.
Gentleman from Jefferson.
Thank you, Mr. Speaker. House Floor Amendment 1 does two things. One, it says that if you live in the if you live in the smaller portion of a district where there's a Chapter 75 fire protection district that goes over more than one county. So in this example, in Jefferson and Oldham County, if you live in that Oldham County portion and you already pay taxes for EMS services provided by the county, then you don't have to pay for the EMS services portion of your bill for the Chapter 75 fire protection district. The other thing that this floor amendment does, Mr. Speaker, is it says that it puts into law what is effectively already happening, and that is our Chapter 75 fire protection districts in Jefferson County. It says that their jurisdiction is only the jurisdiction where there are citizens. I do want to note it does not change any responsibilities to respond to emergencies for Chapter 75 fire protection district EMS services, but it just says that their jurisdiction is the area from which their voters reside. With that, Mr. Speaker, I move adoption of House Floor Amendment 1.
Motion made for the adoption of House Floor Amendment 1. Is there any discussion? Chair recognizes the lady from Jefferson 38.
Thank you, Mr. Speaker. Would the gentleman yield to a question?
Gentleman from Jefferson 33. He would yield.
Thank you. Gentlemen, you mentioned that the first part of the floor amendment involves cross-county provisions, and so I just wanted to make sure that that is correct, that that part only applies to times when two different counties are involved. Is that correct?
Gentleman from Jefferson.
That is correct, Mr. Speaker, in this bill. In the future, it ought to correct the other situation in Louisville, but this bill only has to do with the fire protection district that goes from Jefferson County to Oldham County, and only the Oldham County residents.
Lady from Jefferson.
Would he yield to another question?
He will yield.
Thank you. And then the second part of the floor amendment you said is related to where there are Chapter 75 fire jurisdictions and where their citizens reside and kind of their tax base. So I guess the question I have would be, how will that impact the current runs that they make to date?
Gentleman from Jefferson.
It's a great question. It will not. So the EMS, no matter where they are in Jefferson County, the closest box makes the run, makes the response. We don't support anything different than that.
Lady from Jefferson.
Would he yield to another question?
He will yield.
Thank you. So, gentlemen, with that in mind, then what is the ultimate impact of the language in this second part of the floor amendment?
Gentleman from Jefferson.
Thank you, Mr. Speaker. It clarifies that the Anchorage Middletown Fire Protection District, their district is Anchorage Middletown. The J-Town's the same J-Town, so forth and so on. So it clarifies that their taxpayers are their jurisdiction. They do have to go outside their jurisdiction if their box is the closest. It doesn't have any impact on the services provided, but it does clarify what's true on the ground.
Lady from Jefferson.
That is all. Thank you.
Chair recognizes the gentleman from Jefferson 48.
Mr. Speaker, I just want to comment on the amendment.
May proceed.
This particular addition to this bill is in my district, and it covers the north part of the district. And I have heard from quite a few people in both sides of the county, from Oldham and Jefferson County, that they do not care for, do not want to pay two taxes and so forth, where the services will still continue to be provided and so forth. So I just want to lend my support for this amendment, as well as the support for the overall bill. Thank you, Mr. Speaker.
Question for the body is on adoption of House Floor Amendment 1. Is there any further discussion? Seeing none, all those in favor, please signify by saying aye. Aye. All opposed, nay. Motion carries. House Floor Amendment 1 is adopted. Gentleman from Jefferson.
Mr. Speaker, I move passage of House Bill 236 as amended by House Committee Substitute 1 and House Floor Amendment 1.
Motion made for the passage of House Bill 236 as amended by House Committee Substitute 1 and House Floor Amendment 1. Is there any discussion? Seeing none, Mr. Clerk, sound the chimes. We'll now proceed to vote. All those in favor, please signify by voting yea on the roll call machine. Those opposed, nay. And the roll call machine is open for your voting. Have all members voted? Would any member like to change or explain their vote? Clerk will take the roll. There being 93 members voting yea, no members voting nay, House Bill 236 is amended by House Committee Substitute 1 and House Floor Amendment 1 is passed. Gentleman from Jefferson.
Thank you, Mr. Speaker. Will you please have the clerk report House Floor Amendment 2, the title amendment?
Mr. Clerk, please report.
House Floor Amendment 2, the title amendment to House Bill 236.
Gentleman from Jefferson.
Move adoption, sir.
Without objection, so ordered. Gentleman from Jefferson.
Move the clincher, Mr. Speaker.
Without objection, so ordered. Gentleman from McCracken.
Mr. Speaker, I move you, sir, that House Bill 652 be taken from its place in the orders of the day, read for a third time by title and sponsor only, and placed upon its passage.
Motion made and seconded that House Bill 652 be taken from its place from the orders of the day, read for the third time by title and sponsor only, and placed upon the floor for its passage. Mr. Clerk, please report.
House Bill 652, an act relating to critical facility mapping, making an appropriation therefore and declaring an emergency. Representative Bratcher.
Gentleman from McCracken.
Mr. Speaker, I yield to the gentleman from Hardin for explanation of the bill and motion thereon.
Chair recognizes the gentleman from Hardin for an explanation of the bill and a motion thereon.
Thank you, Mr. Speaker. Please have the House Clerk report House Committee Substitute 1 to House Bill 652.
Mr. Clerk, please report.
House Committee Substitute 1 to House Bill 652.
Gentleman from Hardin.
Thank you, Mr. Speaker. Kentucky, this bill, House Bill 652, deals with Kentucky school data mapping and the data program. This would provide first responders timely and accurate information during an emergency or responding to an event at a school. The first thing this does is moves the program from Center for School Safety to Kentucky Office for Homeland Security and Kentucky 911 Services Board. The other item it does is it ensures the on-site walkthroughs as a part of the mapping process, so they have the most up-to-date and current information. The third thing it does is it ensures the mapping data is compatible with software systems already used by Kentucky public safety agencies. If there are no questions, I move passage of House Bill 652 as amended by House Committee Substitute 1.
Gentlemen, could you make a motion to adopt the sub?
I make a motion to adopt the sub, House Committee Substitute 1 to House Bill 652.
Motion made for the adoption of House Committee Substitute 1. Is there any discussion? Seeing none, all those in favor, please signify by saying aye. Aye. All opposed, nay. Motion carries. House Committee Substitute 1 is adopted. Gentleman from Hardin.
Mr. Speaker, I move for passage of House Bill 652 as amended by House Committee Substitute 1.
Motion made for the passage of House Bill 652 as amended by House Committee Substitute 1. Is there any discussion? The chair recognizes the lady from Jefferson 35.
Thank you, Mr. Speaker. Will the gentleman yield to a question?
He will yield.
Gentlemen, I'm curious to know how this mapping project would be different from the comprehensive mapping already done by the Kentucky Center for...
Gentleman from Hardin.
This only moves it's the same process. It only moves from Center for School Safety to the Office of Homeland Security and 911 Services Board. The purpose of this is to ensure that we have the most timely information during an emergency, and since all state, federal, and local agencies respond, and they use 911 services for their communication.
Lady from Jefferson.
Will the gentleman yield to another question?
You yield.
Thank you. Just for clarity, so this won't actually be remapping, it's just going to move the responsibility from one agency to another?
Gentleman from Hardin.
That is correct.
Lady from Jefferson.
Thank you very much.
Question before the body is on passage of House Bill 652 as amended by House Committee Substitute 1. Is there any further discussion? Seeing none, Mr. Clerk, sound the chimes. We'll now proceed to vote. All those in favor, please signify by voting yea on the roll call machine. Those opposed, nay. And the roll call machine is open for your voting. Would any member like to change or explain their vote? Clerk will take the roll. There being 95 members voting yea, no members voting nay, House Bill 652, as amended by House Committee Substitute 1, is passed. Gentleman from Hardin.
Mr. Speaker, please have the clerk report the House Committee amendment, the title amendment.
Mr. Clerk, please report.
House Committee Amendment 1, the title amendment to House Bill 652.
Gentleman from Hardin.
Move for adoption.
Without objection, so ordered. Gentleman from Hardin.
Move the clincher.
Without objection, so ordered.
Chair recognizes the gentleman from Bullet 49, the chair of the Enrollment Committee, for the Enrollment Committee report. The gentleman from Bullet 49, your committee's been busy.
Yes, sir. Mr. Speaker, the Enrollment Committee has met and found the following bill to be in order and ready for your signature. House Bill 1.
Thank you, Mr. Chairman. Chair is about to sign House Bill 1.
Gentleman from McCracken.
Let's see here. Mr. Speaker, I move you, sir, that House Bill 569 be taken from its place in the orders of the day, read for a third time by title and sponsor only, and placed upon its passage.
Motion made to House Bill 569 be taken from its place in the orders of the day, read for third time by title and sponsor only, and placed upon the floor for its passage. Mr. Clerk, please report.
House Bill 569, an act relating to designation of special judges. Representative Dietz.
Gentleman from McCracken.
Mr. Speaker, I yield to the lady from Kenton 65 for explanation of the bill in motion there.
Chair recognizes the lady from Kenton 65 for an explanation of the bill and a motion thereon.
Thank you, Mr. Speaker. Please have the clerk report House Floor Amendment 1 to House Bill 569.
Mr. Clerk, please report.
House Floor Amendment 1 to House Bill 569.
Lady from Kenton.
Mr. Speaker, I move adoption of House Floor Amendment 1 to House Bill 569.
Motion made for the adoption of House Floor Amendment 1. Is there any discussion? Seeing none, all those in favor, please signify by saying aye.
Aye.
All opposed, nay. Motion carries. House Floor Amendment 1 is adopted. Lady from Kenton.
Thank you, Mr. Speaker. No one should be a judge in their own case. This maxim originated from Roman law in the 17th century. This principle emphasizes the importance of impartiality in legal proceedings, ensuring that judges do not have a personal stake in the outcome of a case to prevent any potential bias. One dilemma that attorneys often face is when a client or a client's interests may be served by asking for the disqualification of a judge who the lawyer or clients believe may have a bias for or against a particular party or issue. The only remedy is to ask that same judge to declare himself or herself biased. Often attorneys must choose not to request disqualification rather than risk retaliation against the client in that case or against that attorney in future cases in that same court. House Bill 569 with the floor amendment merely gives a party to a case or a non-party the ability to ask that independent parties review whether a judge meets the judicial conduct standard of an appearance of bias such that the judge should be disqualified. That review is conducted by the same Chief Justice that now reviews such requests, but without first accusing the very judge who may have a bias and risk retaliation against that client. The Attorney General in this bill is the gatekeeper. House Bill 569 is fair to litigants. It is a fair, independent review of the appearance of bias. It is an anonymous and protects the reputation of judges in our judiciary, and most importantly, preserves the ability of Kentucky attorneys to zealously represent their clients without operating under the fear of alienating the person who will decide many of their clients' fate. Mr. Speaker, I move passage of House Bill 569 as amended by House Floor Amendment 1.
Motion made for the passage of House Bill 569 as amended by House Floor Amendment 1. Is there any discussion? The chair recognizes the lady from Fayette 75.
Thank you, Mr. Speaker. Will the lady yield to a question?
She will yield.
Lady, I'm looking at Section 1B, subsection 2, where it says, any person may submit to the Attorney General his or her affidavit that the judge will not be impartial. I believe you said in your testimony, but I just want to confirm, when we say any person, that includes not only non-parties, but also non-people in the sense that you and I would think about people. It would apply to corporate entities and LLCs, would it not?
Lady from Kenton.
That is correct.
Lady from Fayette 75.
May I speak on the bill?
May proceed.
I have several issues with this bill. The first issue is the separation of powers. The judiciary is an independent body that does not need the Attorney General to make decisions for them. Secondly, when Person A and Person B enter a lawsuit, I don't understand why Corporation C has any stake in that. It seems really scary to me that if you and I need to go to court over something, that a corporation from China could come say, wait, we have a stake. We don't like the judge in this case. Could be a corporation from California who wants something wildly liberal to happen and kick out your local judge. All of these things are legitimate possibilities under this bill. If an attorney is not willing to make a difficult argument, then you have a bad attorney. Attorneys need to be zealous. It's required of us to be zealous. And yes, you do have to weigh difficult decisions. But if your client needs you to make a difficult argument, you've got to be willing to make it. And sometimes that difficult argument is saying to the judge before you, I'm afraid that you're not capable of being impartial, and here's why. If a judge did retaliate, that's what the Court of Appeals is for. There are remedies for any of these problems. And when we open the door for out-of-state non-parties to start interfering in our court system, we're begging for problems.
Chair recognizes the gentleman from Campbell, 67.
Thank you, Mr. Speaker. May I ask the lady from Kenton a question?
She will yield.
Thank you. And I'm not an attorney, so forgive me. But and I guess it's a little bit related to the last question, but I just want to clarify this. When you say any person, does that mean, I'm just trying to understand, do they have to be a party to the case or interested in the case, or does this mean any person just in the general public?
Lady from Kenton.
Any person.
Gentleman from Campbell.
Okay, thank you.
Question before the body is on passage of House Bill 569 as amended by House Floor Amendment 1. Mr. Clerk, sound the chimes. We'll now proceed to vote. All those in favor, please signify by voting yea on the roll call machine. Those opposed, nay. And the roll call machine is open for your voting. Have all members voted? Would any member like to change or explain their vote? Clerk will take the roll. There being 75 members voting yea, 16 members voting nay, House Bill 569, as amended by House Floor Amendment 1, is passed. Lady from Kenton.
Mr. Speaker, please have the clerk report House Floor Amendment 2, the title amendment.
Mr. Clerk, please report.
House Floor Amendment 2, the title amendment to House Bill 569.
Lady from Kenton.
Move adoption.
Without objection, so ordered. Lady from Kenton.
Move to clincher.
Without objection, so ordered. Gentleman from McCracken.
Mr. Speaker, I move you, sir, that House Bill 643 be taken from its place in the orders of the day, read for a third time, by title and sponsor only, and placed upon its passage.
Motion made that House Bill 643 be taken from its place in the orders today, read for a third time by title and sponsor only, and placed upon the floor for its passage. Mr. Clerk, please report.
House Bill 643, an act relating to school safety. Representative Jackson.
Gentleman from McCracken.
Mr. Speaker, I yield to the gentleman from Warren 20 for explanation of the bill and motion thereon.
Chair recognizes the gentleman from Warren 20 for an explanation of the bill and a motion thereon.
Thank you, Mr. Speaker. House Bill 643 is also known as Alyssa's Law. Alyssa was a 14-year-old freshman at Marjorie Stoneman Douglas High School in Parkland, Florida, who lost her life along with 16 other students and staff due to an active shooter on Valentine's Day of 2018. Alyssa's mother has made this her life's mission to help prevent other such horrendous acts. This bill allows school districts to implement a wearable panic alert system to help increase school safety and security for students, faculty, and staff. Each school campus would be dynamically mapped, and when a panic alert signal was sent, it would go straight to the front office, school nurse, and if needed, the local law enforcement and EMS. The bill states as funding is available, it would set up a 50-50 matching grant program through the Center of School Safety. This program would allow another tool providing school safety across the state, but it would not take the place of school resource officers. They will always be our first line of defense in our schools. Mr. Speaker, if there are no questions, I ask for passage of House Bill 643.
Motion made for the passage of House Bill 643. Is there any discussion? Seeing none, Mr. Clerk, sound the chimes. We'll now proceed to vote. All those in favor, please signify by voting yea on the roll call machine. Those opposed, nay. And the roll call machine is open for your voting. Have all members voted? Would any member like to change or explain their vote? The chair recognizes the gentleman from Fayette 79.
Thank you, Mr. Speaker. I just want to compliment the gentleman from Warren 20 for working on this bill in a very collaborative, bipartisan manner for the last couple of years. And I want to thank this body for passing two bills today that would deal with school safety issues. The gentleman from Hardin had a bill a little bit earlier. I think these bills coupled together can make a significant impact on our kids as they go to school across the Commonwealth of Kentucky. So thank you, and I'm excited to support this bill today.
Clerk will take the roll. There being 93 members voting yea, no members voting nay, House Bill 643 is passed. Gentleman from Warren.
Mr. Speaker, I move the clincher.
Without objection, so ordered. Gentleman from McCracken.
Speaker, I move you, sir, that House Bill 442 be taken from its place in the orders of the day, read for a third time by title and sponsor only, and placed upon its passage.
Motion made that House Bill 442 be taken from its place in the orders today, read for third time by title and sponsor only, and placed upon the floor for its passage. Mr. Clerk, please report.
House Bill 442, an act relating to privacy for attorneys involved in criminal actions. Representative Wilson.
Gentleman from McCracken.
Mr. Speaker, I yield to the gentleman from Whitley for explanation of the bill and motion thereon.
Chair recognizes the gentleman from Whitley.
Mr. Speaker, could the clerk please report House Committee Substitute 1?
Mr. Clerk, please report.
House Committee Substitute 1 to House Bill 442.
Gentleman from Whitley.
I move for adoption.
Motion made for the adoption of House Committee Substitute 1. Is there any discussion? Chair recognizes the lady from Fayette, 75.
Thank you. I'd like to comment on the substitute.
You may proceed.
The original version of this bill is so much better, gentlemen. You drafted a great bill. And what has happened with the substitute is that now these protections are in the wrong place. They're less than what these public defenders and prosecutors deserve and need. And there's a strange addition about allowing people to sign our candidacy paperwork and us not know if they live in the district. I think that what you originally proposed, the original version of this bill, is absolutely necessary, essential, and really good policy. But the substitute just fails to achieve the goal, but it also puts in this poison pill that casts doubt on our elections. That's scary. We've been trying to do good work. There have been excellent bills proposed by the lady from Shelby, for example, to make our elections safe. This bill goes in the opposite direction, particularly because of the substitute. I move that we do not accept the substitute.
Question for the body is on passage of House or adoption of House Committee Substitute 1. Is there any further discussion? Seeing none, all those in favor, please signify by saying aye. Aye. All opposed, nay. Motion carries. House Committee Substitute 1 is adopted. Gentlemen.
Thank you, Mr. Speaker. Maybe I should have explained this before I put it up for a vote, but in addition to its regulatory and administrative functions, the Secretary of State administers the Safe at Home program, an address confidentiality program designed to protect certain survivors of certain crimes, including domestic violence, sexual assault, trafficking, and stalking. Through this program, eligible participants may use the Secretary of State's address in place of their actual address on public records, including voter registration rolls. The Secretary of State's office then securely forwards mail to the participant's confidential address. Importantly, the program also enables participants to safely exercise their right to vote through the use of mail-in absentee ballots, balancing personal safety with full civic participation. House Committee Substitute 1 allows prosecutors and public defenders to opt in to the Safe at Home program if they choose to do so. Just last month, a man was sentenced to 42 months in federal prison for interstate communication of a threat. Gentlemen from Knox and gentlemen from Laurel, this man threatened your Commonwealth attorney via email. The news article states that the man, quote, intended the email as a threat and specifically indicated that Mr. Steele needed curtains in his residence and made references to his wife and children that he should fear for the safety of his family. I think it is quite worthwhile to protect from these threats. Ladies from Kenton and gentlemen from Kenton, just over a year ago, a man was arrested for threatening to kill your Commonwealth attorney. The man knew his address and where he goes to the gym. He joined his gym to follow him around. And the investigation showed that he planned to attack him there. So I've had a lot of strange interactions with people, through my time as on Survivor and even here in office now. And so much so that I don't post photos of my children online. If you go to my Facebook, you won't see them, and you never will. So that leads to me showing pictures on my phone or sending Christmas cards, which makes what happened to my Commonwealth attorney in Whitley County actually send chills down my spine. This past Christmas, he received emails threatening him and his wife and toddler children, and the man sent him a threatening Christmas card. He sends a Christmas card to our circuit court judge, which stated, "You should really remove your home address from public information." So, Mr. Speaker, today I hope that we can give them that option to remove that address and to participate in the Safe at Home program, which the Secretary of State is excited about. The hope is that this goes well and we can add more parties. We can add family members or maybe even members of this body, I know many of whom have received threats. So, Mr. Speaker, could you please have the clerk report House Floor Amendment 1?
Mr. Clerk, please report.
House Floor Amendment 1 to House Bill 442.
Gentleman from Whitley.
When these cases happen, oftentimes it's, obviously a prosecutor can't prosecute a case when they're the victim. So oftentimes the prosecution efforts fall to our Chief Prosecutor, the Attorney General. House Floor Amendment 1 adds the attorneys and the Attorney General's office to the list that may participate in the Safe at Home program. I'll move for adoption of House Floor Amendment 1.
Motion made for the adoption of House Floor Amendment 1. Is there any discussion? Seeing none, all those in favor, please signify by saying aye. Aye. All opposed, nay. Motion carries. House Floor Amendment 1 is adopted. Gentleman from Whitley.
I move for passage of House Bill 442 as amended by House Committee Substitute 1 and House Floor Amendment 1.
Motion made for the passage of House Bill 442 as amended by House Committee Substitute 1 and House Floor Amendment 1. Is there any discussion? The chair recognizes the lady from Jefferson 38.
Thank you, Mr. Speaker. Will the gentleman yield to a question?
He will yield.
Gentleman from Whitley, I really appreciate the work that you're doing here today because I think it is much needed. I think there are so many examples of how we need to be protecting our elected officials and folks that are in our communities from this type of criminal behavior. And I guess my question today is, why are we going the route of the Safe at Home program as opposed to our existing statute that protects the privacy of officers of the court?
Gentleman from Whitley.
Well, the Safe at Home program is a newer program. It's operated by the Secretary of State, as I mentioned and went through, and it's going well. They're excited about the opportunity for the program to grow, to add more members of the program that are seeking that protection, and it offers the opportunity to forward mail. As far as I'm aware, the other option that was in the original bill that filed, they don't have that option to where you can just use a different address. Your address is still going to be out there. You're going to have to use it to get your bills and to get your mail. In the Safe at Home program, you use the Secretary of State's address, but you still get your mail.
Lady from Jefferson.
May I speak on the bill?
You may proceed.
I think the Safe at Home program is a wonderful program, and especially for those members of our community who've experienced domestic violence. I do have concerns, though, that we're going this route in particular on folks that are related to our court system. I think the statutes that protect the privacy of court officers is the stronger statute, that should be the precedent that we're going with, because we do want to keep these folks safe. But I think that is a much more appropriate place to provide that protection instead of the Safe at Home program. I think the Safe at Home program has a certain place in our community, but this is specific to those that find themselves in a court setting, and I think we should be consistent with that statute. So I don't really want to be a no on this bill today because I love the intent of where we're trying to go, but I just don't think this is the appropriate vehicle for making this protection happen. Thank you, Mr. Speaker.
Question for the body is on passage of House Bill 442 as amended by House Committee Substitute 1 and House Floor Amendment 1. Mr. Clerk, sound the chimes and now proceed to vote. All those in favor, please signify by voting yea on the roll call machine. Those opposed, nay, and the roll call machine is open for your voting. Have all members voted? Would any member like to change or explain their vote? Clerk will take the roll. There being 89 members voting yea, 4 members voting nay, House Bill 442 is amended by House Committee Substitute 1 and House Floor Amendment 1 is passed. Gentleman from Whitley.
I move for the clincher.
Without objection, the clincher is applied. Gentleman from McCracken.
Mr. Speaker, I move you, sir, that House Bill 607 be taken from its place in the orders of the day, read for a third time by title and sponsor only, and placed upon its passage.
Motion made that House Bill 607 be taken from its place in the orders of the day, read for a third time by title and sponsor only, and placed upon the floor for its passage. Mr. Clerk, please report.
House Bill 607, an act relating to consolidated local governments. Representative Chris Lewis.
Gentleman from McCracken.
Mr. Speaker, I yield to the gentleman from Jefferson 29 for explanation of the bill and motion thereon.
Chair recognizes the gentleman from Jefferson 29 for an explanation of the bill and motion.
Thank you, Mr. Speaker. Would you please have the clerk call House Committee Substitute 1?
Mr. Clerk, please report.
House Committee Substitute 1 to House Bill 607.
Gentleman from Jefferson.
Thank you, Mr. Speaker. It was suggested to me earlier today that I should stand before this body and declare that this is a Louisville bill and simply motion for passage. But I'll take just a moment to explain if you all will indulge. Thank you. This bill is the culmination of more than a year's work, and throughout the process, we consulted with members of the Louisville Metro Council, Mayor Greenberg and his staff, as well as a representative with the Jefferson County Attorney's Office. I want to be clear that this legislation only impacts the city of Louisville, which is the Commonwealth's only consolidated local government created by statute 67C. First, the bill restructures the appointment authority for the Ethics Commission, splitting appointments between the mayor and Metro Council, and it also requires political party diversity. No more than 3 members of the same party may serve simultaneously. And it requires the commissioners must have been registered with their appointing party for a minimum of 4 years prior to taking office, preventing last-minute party changes. The bill moves the Office of Internal Audit from the Mayor's office to the Metro Council, and it transfers appointment authority for the auditor from Mayor to the Metro Council, which is the legislative body responsible for oversight of all city agencies. Next, the bill establishes a few guidelines for redistricting. It requires that populations not vary by more than 2.5%, district populations not vary by more than 2.5%, and precinct splits are prohibited unless necessary to satisfy the 2.5% population requirement. Next, the bill allows both caucuses within Metro Council to retain independent legal counsel for legislative advice, consultation, or to prepare and review legislation. The bill allows for any regulations passed by the Board of Health or the Solid Waste Management District to be reviewed and overridden by the Council within 45 days of issuance. The final provisions of this bill relate to the tax structure and rates inside of the Urban Services District, or what is commonly referred to as the Old City of Louisville prior to merger. This bill will provide Council the flexibility to modify those rates only within the Urban Services District, not the county as a whole, to encourage development of vacant land. Mr. Speaker, if there are no questions, I move passage of House Bill 607 as amended by House Committee Substitute 1.
Gentlemen, would you withdraw that and make a motion to adopt the House Committee?
Yes, sir. I make a motion to adopt House Committee Substitute 1.
Question for the body is on adoption of House Committee Substitute 1. Is there any discussion? Seeing none, all those in favor, please signify by saying aye. Aye. All opposed, nay. Motion carries. House Committee Substitute 1 is adopted. Gentleman from Jefferson.
Thank you, Mr. Speaker. I move passage of House Bill 607 as amended by House Committee Substitute 1.
Motion made for the passage of House Bill 607 as amended by House Committee Substitute 1. Is there any discussion? Lady from Jefferson 38.
Thank you, Mr. Speaker. May I speak on the bill?
Yes, ma'am.
I promise. This is my last bill I'll speak on today. Oh, there we go. I'm feeling inquisitive. So, following last week's local government committee, I had the opportunity to work with the gentleman from Jefferson 29 on House Bill 607, where he was able to put several of my concerns to ease. And I do mean gentleman from 29 because he was quite the gentleman when speaking to me afterwards. He really did take the time to listen, and even though we disagreed, we really were able to better understand each other. So currently my main issues with the bill are on the pieces regarding the Metro Council redistricting and the local health and solid waste management boards. The protections in the bill that would be put into place for the Louisville Metro Council's redistricting process are standards that we do not require by statute at our state level. And I would like to see consistency in this process where possible. I also find it unnecessary for the bill to single out a process for the Louisville Metro government to overturn decisions made by the local health board and also Solid Waste Management District Board when the Metro Council already has this power to overturn their decisions. And I worry about the bill, its specificity could discourage the community from having dialogue around conversations about how they want their waste to be collected. These opinions are my own, and they're informed by conversations I've had with constituents and my own professional experiences. Louisville is a big and diverse place, and I acknowledge that my colleagues may have different experiences in their jurisdictions and their time serving the public. However, I do not feel that we need to touch 67C this session, and I'll continue to be a no on the bill. If we did touch 67C this session, I think that it should be much narrower in scope. There are good provisions being laid out having to do with the Ethics Commission, for example. But I would love to see that kind of on its own. So while I appreciate the bill also has property taxation changes that I think could be a benefit to Louisville Metro as well. So I want to thank the gentleman for hearing my feedback and working with me to ensure that the bill does what it's meant to do. So thank you, Mr. Speaker.
Chair recognizes the gentleman from Jefferson 30.
Thank you, Mr. Speaker. Would the sponsor yield to a question?
He will yield.
Sponsor, how is it constitutional to have such a bill that applies to only Louisville?
Gentleman from Jefferson.
Mr. Speaker, I'm going to defer to the gentleman from Jefferson 33.
Chair recognizes the gentleman from Jefferson 33.
Thank you, Mr. Speaker. I think it's section 156. I'll look and get it to the gentleman, but there is actually a section in the Constitution that says that we can set up cities and cities in any way that we want to. So unlike, for example, I think you're referring to the recent Supreme Court opinion that talked about the Jefferson County Public Schools being treated differently, there's actually a section in the Constitution that deals directly with the creating statutes for cities. And I'll get that statutory reference to you momentarily. Or that constitutional reference, I'm sure, momentarily.
Gentleman from Jefferson.
Thank you, Mr. Speaker. Would the sponsor yield to a second question?
He will yield.
Sponsor, theoretically, the county attorney could be facing an ethics inquiry. How do we handle the conflict of interest of the county attorney appointing the special attorney to investigate the county attorney in such a case?
Gentleman from Jefferson.
Yeah, thank you, Mr. Speaker. Gentlemen, I believe the county attorney could still hire outside legal counsel that is outside of the county attorney's office.
Gentleman from Jefferson.
Thank you, Mr. Speaker. No more questions.
Question for the body is on passage of House Bill 607 as amended by House Committee Substitute 1. Is there any further discussion? Seeing none, Mr. Clerk, sound the chimes. Now proceed to vote. All those in favor, please signify by voting yea on the roll call machine. Those opposed, nay. And the roll call machine is open for your voting. Have all members voted? Would any member like to change or explain their vote? Chair recognizes the gentleman from Jefferson 33.
Thank you, Mr. Speaker. That reference was section 156A of the Constitution. Thank you.
Clerk will take the roll. There being 76 members voting yea, 14 members voting nay, House Bill 607, as amended by House Committee Substitute 1, is passed. Gentleman from Jefferson.
Mr. Speaker, I move the clincher.
Without objection, so ordered. Gentleman from McCracken.
Mr. Speaker, I move you, sir, that House Bill 78 be taken from its place in the orders of the day, read for a third time by title and sponsor only, and placed upon its passage.
Motion made that House Bill 78 be taken from its place in the orders of the day, read for a third time by title and sponsor only, and placed upon the floor for its passage. Mr. Clerk, please report.
House Bill 78, an act relating to firearms liability protections and declaring an emergency. Representative Roberts.
Gentleman from McCracken.
Mr. Speaker, I yield to the gentleman from Boone, 66, for explanation of the bill and motion thereon.
Chair recognizes the gentleman from Boone, 66, for an explanation of the bill and a motion thereon.
Thank you, Mr. Speaker. Mr. Speaker, will you have the clerk please report House Committee Substitute 1 to House Bill 78?
Mr. Clerk, please report.
House Committee Substitute 1 to House Bill 78.
Mr. Speaker, House Committee Substitute 1 removes the retroactivity language and adds further clarification to be clear that we're just simply codifying the federal standards outlined in PLACA, which was passed in 2005. So that I move adoption of House Committee Substitute 1.
Motion made for the adoption of House Committee Substitute 1. Is there any discussion? Seeing none, all those in favor, please signify by saying aye. All opposed, nay. Motion carries. House Committee Substitute 1 is adopted. Gentleman from Boone.
Mr. Speaker, no branch of government and no level of government, whether that be federal, state, or local, judicial, legislative, or executive, can override constitutional rights. This body recognized that principle when we adopted House Bill 222 in 2022 to protect the First Amendment from frivolous and meritless litigation. That bill carried unanimously in the House. Congress also recognized that in relation to our Second Amendment rights when they, on a bipartisan basis, passed the Protection in Lawful Commerce and Arms Act of 2005, which makes clear what stands to common sense, that criminals should be held liable for their actions, not manufacturers, not sellers, who had no clue that someone was going to act in that way. So they codified this law that makes clear that these manufacturers and sellers can be held liable when they violate an express gun law, such as the Gun Control Act of 1968, the National Firearms Act, the Arms Export Control Act. They made clear further that negligent entrustment or negligence per se is still an available avenue of recovery in these situations. They further say you can still sue over product defects, design defects, those types of issues. But whenever it comes to someone who followed the law and sold a firearm and it is later used in a crime, the criminal is the person who should be held accountable. This codifies that at the state level, and the reason for that need is that the PLCAA has what's known as a predicate exception that federal courts have warned enables for states to construe their laws so broadly that it swallows the entire federal statute. That is not our role, and we have to ensure that our constitutional rights are protected from extra legal efforts to suppress these basic rights. So, Mr. Speaker, I just want to give a shout out as well to the people who've been working really hard on this bill, the gentleman from Hopkins, the gentleman from Letcher. If there was a rule on for 2 primary co-sponsors, these folks would do it. So I just wanted to thank them for that. And with that in mind, I move for passage of House Bill 78 as amended by House Committee Substitute 1.
Motion made for the passage of House Bill 78 as amended by House Committee Substitute 1. Is there any discussion? Chair recognizes the lady from Franklin 57.
Thank you, Mr. Speaker. Will the sponsor yield to a question?
He will yield.
Sponsor, would you agree that determining whether a claim has merit is traditionally the role of the court, not the legislature?
Gentleman from Boone.
Mr. Speaker, it is the role of the legislature to determine what the law is. It is the role of the jury to determine whether the facts meet a claim under the law. What this is doing is simply enshrining something that has already been the law for 21 years already to ensure the basic principle that these sellers, these manufacturers, are protected so long as they follow the federal laws, so long as they follow the state level laws. There's a 4473 background check. Every single person who purchases a firearm has to take it if they purchase from a federal firearms license holder. The laws demonstrate where this is, and right now we see out of control states suing companies simply on the grounds of, for example, California filed a lawsuit against Glock because they failed to engage in court efforts to issue prior restraint orders against rappers for mentioning their company in songs. This is not a valid claim, and it is within our purview as a legislative body to clarify when these laws apply. And that's what this bill does. Now, if we have a true negligence claim, suppose someone sold to someone that they should have known was a convicted violent felon. Absolutely, that is still within the jury. This bill does not disturb that. So with that in mind, we have the right to write the law. The juries have the right to determine the facts of the law.
Thank you, Mr. Speaker. Thank you, Mr. Speaker. May I speak on the bill?
You may proceed.
In committee, the sponsor mentioned that this bill simply clears up
when the courts can intervene. Certainly, it is the role of the legislature to write laws and establish policy, but it has always been the role of the courts to determine how those laws apply to real situations and whether claims brought before them have any merit. That balance between writing the law and interpreting the law is fundamental to our system. Federal law already provides significant protection to firearms manufacturers through the Protection of Lawful Commerce in Arms Act. But even within that law, Congress recognized that courts should still be able to examine cases where there are allegations that company violated laws governing the sale and marketing of firearms. One example is the case following the Sandy Hook Elementary School shooting, where families brought a claim against Remington Arms. That case focused on whether the company's advertising practices violated consumer protection laws. A court allowed that claim to proceed, and it ultimately resulted in a $73 million settlement with the families. That outcome was not determined in advance by a legislature. It came from a court examining evidence and applying the law. What concerns me about this legislation is that it does more than clarify the law. It limits the ability of the courts to examine those questions in the first place. As a survivor of gun violence, I have often heard the phrase, guns don't kill people, people kill people. And I understand the point about individual responsibility. But accountability in our system does not stop with the individual who commits the crime. Courts exist so that when tragedy happens, the facts can be examined and responsibility can be determined wherever it belongs. Accountability strengthens public safety. When negligent practices exist anywhere in the chain of conduct, our justice system should have the ability to examine them. Mr. Speaker, legislatures write laws. Courts examine the facts. And for those reasons, I will be voting no.
Chair recognizes the lady from Jefferson 32.
Yes, may I ask the sponsor a question?
Here with you.
Okay, on page 2 of the bill, it says, a manufacturer or seller of firearms or ammunition shall not be subject to any claim for damages in any negligent marketing action unless all of these following conditions are met. And one condition is that there is a direct and proximate causal link between the marketing practice and the alleged harm claimed by the plaintiff. I'm not an attorney, but I know a bit about research, and to do a causal study is expensive. So my question is, are you aware of how much money is appropriated either at a federal or a state level to fund research regarding firearms?
Gentleman from Boone.
Mr. Speaker, that's in the original draft. That's not in the committee substitute, but further causation is an essential element to all civil claims.
The lady from Jefferson.
May I speak on the bill?
May proceed.
So in Kentucky, the leading cause of death for children and teens is firearm injuries. So here we're going to provide a measure to protect manufacturers, but does this bill do anything to address the harm of victims of gun violence? We've already seen what reckless gun marketing can look like. In the Sandy Hook case, families challenged Remington's militaristic advertising of the Bushmaster rifle, and that case resulted in a $73 million settlement. This legislation gives the gun industry a special legal protection that almost no other industry enjoys. If a car company acts negligently, it can be sued. If a drug company hides risks, it can be sued. But this bill would make it far harder for Kentucky families to seek justice when irresponsible practices contribute to harm. This is not about taking away anyone's rights to own firearms. It is about accountability. When companies ignore warning signs in their distribution chains or engage in negligent practices, our courts should remain open to the people of Kentucky. We should not grant immunity in this style to any industry. For these reasons, I respectfully ask for a no vote.
Chair recognizes the lady from Fayette 76.
Thank you, Mr. Speaker. Would the sponsor yield to a question?
He will yield.
Sure. Are there any current lawsuits going on against gun manufacturers in the state of Kentucky, Commonwealth?
Gentleman from Boone.
There is, but the retroactivity was taken out, so there would be no effect at this phase of litigation.
Lady from Fayette.
Okay, thank you. My bill book still says that there is an emergency clause on here, so that may not be. May I speak on the issue? Thank you. With this bill book still saying that there is an emergency on here, my understanding is that this law would impact the ongoing lawsuits that haven't been resolved yet. So I want to make sure that people who are going through a lawsuit right now under the law as they have been, would still be able to have judicial interpretation of the law. So that's my concern with it, and I am also not a lawyer, but I will again echo my colleagues that this isn't about one's right to own a gun. This is about making sure that we are doing right by the people. Thank you.
Gentleman from Boone, would you like to describe the difference between emergency clause and retroactivity?
Yes, Mr. Speaker. So retroactivity means that the law is to be applied for cases that are currently pending. An emergency clause simply means that the bill takes effect upon its passage by the House and Senate and signature of either the governor or the Secretary of State. It doesn't mean that it applies retroactively. That is not in this bill, so there is no retroactive application of this bill.
Chair recognizes the lady from Fayette, 93.
Thank you, Mr. Speaker. May I speak on the bill?
May proceed.
Thank you. I want to make one point of clarification before I give the rest of my thoughts, or share the rest of my thoughts. In 1803, Marbury versus Madison established that it is emphatically the province and duty of the judicial department to say what the law is. That aside, I rise today in opposition of House Bill 78, and I want to say this. I want to be very, very clear. No one in this chamber wants to see law-abiding gun owners, responsible dealers, or ethical manufacturers dragged into court unfairly. But that's not what this bill is really about. This bill goes far beyond protecting responsible actors in the firearms industry. It erects a near impenetrable legal wall that shields bad actors from accountability, and it does so at the expense of Kentucky victims of gun violence. This bill creates a dramatic limitation on accountability. It grants broad immunity to gun manufacturers and sellers when their products are used unlawfully, even in cases where negligence may have contributed to harm. It only allows lawsuits to proceed under extremely narrow circumstances, shielding the entire gun industry from most civil claims, even when bad actors are involved. This bill would also set a nearly impossible legal standard. Victims would have to prove all elements of their claim by clear and convincing evidence, a much higher standard than typical civil cases, which require only a preponderance of evidence. This bill also requires that not just any law, but only a law explicitly regulating firearms and ammunition that sets clear, specific, and unequivocal requirements can serve as the basis for a claim. So it's impossible to satisfy these standards, making legitimate lawsuits highly unlikely. Consider what this bill actually does. It imposes steep financial penalties, up to $250 per day on any person, including their attorney, who brings a claim that a court later finds is barred. That's not a neutral procedural rule. That is a deliberate deterrent designed to make lawyers think twice before they ever agree to represent a grieving family. This also strips Kentucky courts of the ability to apply our own common law nuisance doctrine and our own consumer protection statutes to the firearms industry. Whatever you think of those claims on the merits, that question should be answered by Kentucky judges applying Kentucky law, not preemptively foreclosed by this legislature. Kentuckians deserve accountability. Kentuckians deserve their day in court, and I urge all of you to vote no. Thank you, Mr. Speaker.
Chair recognizes the gentleman from Fayette, 45.
Thank you, Mr. Speaker. Wish to speak on the bill?
May proceed.
Thank you, sir. Just to get out of the way at the beginning, of course, those of us who are speaking either against this or having this debate today, it doesn't have anything to do with the Second Amendment rights. We're talking about the integrity of our legal system. We're talking about consumer protections here in Kentucky that would potentially be on the line should we pass House Bill 78 today. Now, this body, before I got here, but hopefully I'm part of it now, has been working to craft a stable, predictable legal environment that allows businesses to play by the rules, but also protects our consumers and protects them and gives them a path to justice when those rules are broken. But as my friend from Fayette 93 just mentioned, House Bill 78 does create a legal island that does offer specific protections to one industry alone, those such that are not benefited by any other industry or business in the state of Kentucky, no matter how vital that business or industry is. We talk a lot about local control in this chamber, but House Bill 78 explicitly strips our local leaders of their authority. It says that even if a local community identifies a specific localized threat to public safety caused by a business's conduct, they cannot seek a judicial remedy. We're effectively telling our cities and our counties that when it comes to this one singular industry, that local control ends at the courtroom door. Second, and even more concerning, is what it does to consumer protections. The second time we spoke about that on this floor today. Now, recently we've addressed data privacy and transparency in this body. We've told Kentuckians that they have the right to know that they are being targeted by sophisticated marketing algorithms, but House Bill 78 creates a massive loophole there. Because under the Kentucky Consumer Protection Act, if a company uses unfair, false, or deceptive marketing to target your family, you have the right to hold them accountable. But if this bill passes, we are raising the bar so high for this one unique industry that those protections essentially vanish. Unless a manufacturer violates a law specifically written just for firearms, they are shielded. This means that they can use the most aggressive, individualized data mining and inference techniques to target the most susceptible Kentuckians. And the standard consumer protections that we afford to every other product, from toys to tractors, simply won't apply. Mr. Speaker, we are choosing to weaken the rights of Kentucky consumers to benefit one single industry. If a pharmacy mislabels a bottle, they're liable. If a contractor in Fayette County uses deceptive advertising, they are liable. They don't get a special motion to dismiss. They don't get a mandatory stay of discovery. They don't get a specialized shield that preempts local concerns. I'm for a fair legal system, but a fair system requires that rules apply to everyone equally, and House Bill 78 fails to meet that test. It tells the people of Kentucky that their consumer rights depend on who harmed them rather than how they were harmed. So for the sake of our local communities and the strength of our consumer protections, I urge a no vote today. Thank you.
Chair recognizes the lady from Jefferson 35.
Thank you, Mr. Speaker. May I speak on the bill?
You may proceed.
Thank you. Mr. Speaker, members, in my community, we have a gun violence problem. We have a gun violence problem in our country. And today we passed 2 school safety bills, I think both of them unanimously, to protect our students from gun violence. So this body understands that we have a gun violence problem in our state. Since I've been in this body, I've sponsored and I've co-sponsored common sense gun legislation to protect my community and all Kentuckians from gun violence. Those bills, safe storage, background checks, voluntary do not sell list, and others would protect Kentuckians. But this bill is designed to protect gun manufacturers, but it does nothing to protect ordinary Kentuckians. It does nothing to protect my constituents, to protect your family members, to protect our neighbors. These are the kinds of protections that our people deserve, not to, honestly, it's an insult to protect gun manufacturers when our own people are at risk in our own communities. I'll be a no on this bill today.
Chair recognizes the lady from Jefferson 41.
Thank you, Mr. Speaker. May I speak on the bill?
Yes, ma'am.
Thank you so much. I'm sure everybody knows how I'm going to vote on this bill today. But once again, we are attempting to give a billion-dollar industry protection from lawsuits. and not protecting our families, our neighbors, our constituents. You know, one of the first gun violence school shootings that I heard on the news was Columbine, and watching all those kids running out of the school with their hands over their heads. I can't remember, 20-something murdered. The instigators murdered. But not to be able to take someone to court, take a manufacturer to court, and rule either for or against you. That's what America's about, to be able to take someone to court if you feel aggrieved or you feel like the gun manufacturer was at fault in that. But since Columbine, we've had 510 school shootings. So what we're doing, that's been across the country, but we've had, I don't know if y'all remember Paducah. In like 1995, there was a Paducah school shooting. We've had Marshall County, 3 or 4 killed there. So if any of those families or those neighbors or those friends of yours would want to take a manufacturer to court and get redress, perhaps the murder of their child, or that the fact that their child is in a wheelchair for the rest of his or her life. Unfortunately, what we're telling them with this bill is, that's just too bad. So sorry about your luck, Chuck. We even had a bill today that we named after a survivor or a victim of Marjorie Stoneman Douglas High School in Parkland, Florida, the Alyssa Aldahoff Act for school safety. We even had, I guess, the nerve to name a bill after a child that was killed in a high school shooting. And the fact that that kid lived in Kentucky with this bill, they couldn't get redress. So I don't know why we want to protect these billion-dollar industries, million-dollar industries. And I know I can be pretty naive sometimes, but one time someone told me, if you look at every bill, the bottom line is they're always about money. I hate to think that. I always think that we're doing the work of the people. We're doing the work of our neighbors. We're trying to keep our communities safe, to be just, to give the neighbor and the working man and woman a hand, a chance to be able to have a say in what happens. But with this bill, we're stacking the deck against them. And may God help us if any of these school shootings ever happen to our kids or our grandkids, and we can't have redress. And I'll be voting no on this bill. Thank you, Mr. Speaker.
Chair recognizes the lady from Jefferson 34.
Thank you, Mr. Speaker. Permission to speak on the bill, please.
Yes, ma'am.
Thank you so much. House Bill 78 is a value statement. It tells us that a corporation's bottom line is more sacred than a Kentuckian's life. Since when did immunity become a Kentucky value? If an industry is too dangerous to be held accountable by a jury of our peers, it's too dangerous to be protected by our laws. Accountability isn't an attack. It is the price of doing business in a free society. So let's stop protecting profit margins and start protecting each other and our children. I will be a no vote.
Chair recognizes the lady from Fayette 75.
Thank you, Mr. Speaker. Will the gentleman yield to a question?
He will yield.
I am looking at page 6, lines 10 through 13, which are subsection 5C. And what it says there is a civil penalty of not less than $100 per day and not more than $250 per day will be penalized against a filer of a case brought under this section after the effective date. Are there any other civil rights of action for which we fine plaintiffs for bringing something fraudulent? And if so, what are they, please?
Gentleman from Boone.
Mr. Speaker, that's in just about every civil cause of action under Rule 11. The problem that we have under Kentucky Civil Rule 11 is that it's just rarely enforced. This is giving a statutory remedy to be clear that when frivolous suits are filed, taking judicial time from meritorious cases such as true negligence, which is allowed under this bill, that there is an avenue to make sure that that there is accountability for the fraudulent filings. We also passed that in House Bill 2 last session as well, that gave a civil penalty for instances of civil actions as well.
Lady from Fayette.
Thank you for the answer. May I speak on the bill?
May proceed.
Only one person has noticed today that I wore my dissent collar. Like the justices of the Supreme Court who stand against things that require voices to rise up against a majority. There already is Rule 11, and so if someone brings a fraudulent claim, there can be penalties for that. However, that's in the discretion of the court. Here, putting this in statute serves no purpose other than to prevent families who are in crisis from making a decision whether or not they want to file a claim. This is a chilling provision intended to scare people away from seeking their day in court. If their case is on the line, their attorney would have to advise them, you're running the risk of not only having to pay my attorney's fees, but their attorney's fees, and a huge penalty every single day that this is sitting in court if the judge doesn't agree with me, like I agree with you, that this case is meritorious. So it's stacking the deck against Kentucky families. It's keeping them from going to court when their family has been harmed. I said it in committee, and I'll say it again today. There is no universe in which I'm going to vote yes to protect gun manufacturers when I can't get a bill heard to protect children. What are we doing?
Chair recognizes the gentleman from Boone, 66.
Thank you, Mr. Speaker. I just want to correct the record on a few of the statements that were made. So first of all, in the notion of Marbury versus Madison, meaning that the judiciary gets to declare the law at any point in time, Marbury versus Madison was a case about the Judiciary Act, which was enacted by Congress, because they are the lawmaking branch of government. As here, we are the policy-making branch. The Kentucky Supreme Court has repeatedly given that. And this branch, by the way, has given avenues for accountability when families are struck by criminals, and that's criminal act damages. If you are injured, if you suffer harm as a result of the actions of a criminal, you can sue that criminal. Whom you should not be able to sue are the people that had ultimately nothing to do with it. We don't see this in other industries. I think of an incident in Waukesha, Wisconsin, where a man drove a truck through a crowd of people. I don't think the manufacturer of the truck was sued. I don't think the dealer of the truck was sued. But we see this constant abuse of the court specifically aimed at this industry, where even foreign governments have attempted to utilize our court to nullify a constitutional right. Mexico sued Smith & Wesson in one of the most frivolous lawsuits that I have ever seen, and it took a trip all the way to the United States Supreme Court, where with no dissents, they unanimously said it was frivolous. But the reality is, if they had staged a state-level claim here in Kentucky without this legislation, it could have gone very differently. And the reality is this: I don't want foreign governments telling us that we can't exercise our constitutional rights. On to the claim that there is absolutely no avenue of recovery. If a seller violates the Gun Control Act, if they don't issue a Form 4473, you can still sue that seller in that situation. That's what negligent entrustment is. That's what negligence per se is. There are plenty of avenues. This is designed to just line us up with the federal PLACA bill in order to ensure that that predicate exception does not swallow the statute. And by the way, the narrative that this has nothing to do with the Second Amendment just is not true. If there is no industry, if there is no supply, that right may as well not even exist. And that is the point of this bill. Likewise, if anyone can be sued for anything they said, there may as well not be a First Amendment. That is why we adopted our anti-SLAPP statute. So with all those in mind, we need to pass this bill, and I move for adoption of House Bill 78 as amended by House Committee Substitute 1.
Mr. Clerk, sound the chimes. Now proceed to vote. All those in favor, please signify by voting yea on the roll call machine. Those opposed, nay. And the roll call machine is open for your voting. Have all members voted? Would any member like to change or explain their vote? Chair recognizes the gentleman from Boyle, 54.
Thank you, Mr. Speaker. I would like to explain my yes vote. Thank the gentleman for bringing this bill. These lawsuits are designed to bankrupt the gun industry. That's why they're filed. And if that were to ever happen in this country, that would end the Second Amendment. So that's why I'm voting yes.
Clerk, take the roll. There being 75 members voting yea, 17 members voting nay, House Bill 78 as amended by House Committee Substitute 1 is passed. Gentleman from Boone.
Mr. Speaker, move you, sir, that the motion by which House Bill 78 as amended by House Committee Substitute 1 be reconsidered and that the motion to reconsider be laid on the table.
Without objection, clinchers applied. Gentleman from McCracken.
Mr. Speaker, that concludes the orders of the day.
Next order of business is motions, petitions, communications, and announcements. Gentleman from McCracken.
Mr. Speaker, I have several motions I need to make, but before I make those motions, I wish to make an announcement. Members, please take note that this evening, our friends at McCarthy Strategic Solutions are sponsoring a St. Patrick's Day reception at Goodwood Brewing from 5 to 9 p.m. They have invited all the members of the House, and you are encouraged to attend. Mr. Speaker, I move you, sir, that House Bill 672 and 673 be taken from the Committee on Appropriations and Revenue, given their second reading, and then returned to the Committee on Appropriations and Revenue.
Without objection, so ordered. Mr. Clerk, please report.
House Bill 672, Representative Petrie, an act relating to branch budget bills. And House Bill 673, Representative Petrie, an act relating to branch budget bills.
Gentleman from McCracken.
Mr. Speaker, I move you, sir, that Senate Bill 245, House Bill 818, House Bill 849 be taken from the Committee on License and Occupations and Administrative Regulations, given their second reading, and then returned to the Committee on Licensing, Occupations, and Administrative Regulations.
Without objection, so ordered. Mr. Clerk, please report.
Senate Bill 245, Senator Webb, an act relating to tobacco, nicotine, or vapor product licensure and declaring an emergency. House Bill 818, Representative Osborne, an act relating to alcoholic beverages. And House Bill 849, Representative Derek Lewis, an act relating to administrative regulations.
Gentleman from McCracken.
Mr. Speaker, I move you, sir, that House Bill 925 be taken from the Committee on Natural Resources and Energy, given its second reading, and then returned to the Committee on Natural Resources and Energy.
Without objection, so ordered. Mr. Clerk, please report.
House Bill 925, Representative Miles, an act relating to wind energy.
Gentleman from McCracken.
Mr. Speaker, I move you, sir, that House Bill 649 and House Bill 852 be taken from the Committee on Primary and Secondary Education, given their second reading, and then returned to the Committee on Primary and Secondary Education.
Without objection, so ordered. Mr. Clerk, please report.
House Bill 649, Representative Scott Lewis, an act relating to education, and House Bill 852, Representative Fleming, an act relating to education.
Gentleman from McCracken.
And Mr. Speaker, I move you, sir, that House Joint Resolution 86 be taken from the Committee on State Government, given its first reading, and then returned to the Committee on State Government.
Without objection, so ordered. Mr. Clerk, please report.
House Joint Resolution 86, Representative Miles, a joint resolution directing the Personnel Cabinet in consultation with the Kentucky Department of Agriculture to integrate community-supported agriculture purchases into the wellness rewards programs offered to public employees and retirees who receive health insurance coverage through the Kentucky Employees Health Plan.
Gentleman from McCracken.
Mr. Speaker, at the moment, that's all I have for motions, petitions, communications, and announcements.
Chair recognizes the lady from Franklin, 57.
Thank you, Mr. Speaker. May I address the body?
You may proceed.
We can do some bar hopping tonight. There's also a County Clerks Association at the Foundry from 6 to 8. Come down and see us there.
Chair recognizes the gentleman from Davis, 13.
Mr. Speaker, I'd like to act on a resolution.
You may proceed.
I would like to call House Resolution number 32 and have it read by title only.
Mr. Clerk, please report.
House Resolution 32, a resolution recognizing March 17th, 2026 as Profound Autism Day in Kentucky. Representative Johnson.
Gentleman from Davis.
Thank you, Mr. Speaker. I rise today to recognize Profound Autism Day in Kentucky and to bring attention to the individuals and families across our Commonwealth living with the most severe forms of autism. Autism exists on a spectrum, and those with profound autism often face the greatest daily challenges. Many are nonverbal and require lifelong care and support. Their families, caregivers, teachers, and therapists show extraordinary dedication and strength every single day. Today is about recognizing those Kentuckians and the commitment of the people who stand beside them. It's also a reminder that those navigating severe autism often face barriers to service and support, and our work as policymakers can make a meaningful difference. I ask my colleagues to join me in recognizing Profound Autism Day in the Commonwealth and in honoring the individuals, families, and caregivers whose perseverance inspires us all. Mr. Speaker, I move for adoption of the resolution.
Without objection, the resolution is adopted. Chair recognizes the gentleman from Jefferson, 33.
Thank you, Mr. Speaker. May I make an announcement to the body?
May proceed.
I'd like to announce that the impeachment committee will meet tomorrow at noon. Thank you, Mr. Speaker.
Please take note. Chair recognizes the lady from Jefferson, 32.
Yes, so I should have asked to speak after the gentleman just spoke. So I'd like to call citation 73.
Mr. Clerk, please report.
Citation 73, Representative Bojanowski. Citation of recognition, the House of Representatives of the Commonwealth of Kentucky hereby recognizes and honors Profound Autism Day, March 17, 2026.
Lady from Jefferson.
So, same topic, same important acknowledgement of individuals with autism who actually have a more profound type of autism. My son was diagnosed with autism when he was 2.5. He didn't put two words together until he was 3.5. I really didn't know where his path would lead. But one day when we were driving downtown to give blood, he tells me I would rather give them my poop than give them my blood. And I knew he was going to be okay. But so many individuals who were in the cohort of wonderful people I met as my son made this path through the world of autism have a much different situation. And I shared one day, I brought in my student Carter, and he is going to need support and care his entire life. But he also has so much to give to us. You go and watch him play baseball, or you try to teach him how to carry digits. You know, he has so many skills. And I think that what this recognition of Profound Autism Day does is it not only uplifts the concerns we have, but it uplifts the strengths that these individuals have, and we want to celebrate them and acknowledge what contribution they can give to society. So I thank you in recognizing Profound Autism Day twice, and I think it's a very important thing to do. Thank you, sir.
Without objection, citation is adopted. Chair recognizes the lady from Shelby 58.
Make an announcement.
May proceed.
The Judiciary Committee will meet in the morning at 10 o'clock in room 149. Thank you.
Members take note. Any other members seeking recognition, motions, petitions, communications, and announcements? Seeing none, the next order of business is introduction of new resolutions. Mr. Clerk, please report.
House Resolution 123, Representative Thompson, a resolution recognizing March 19, 2026 as Random Acts of Cody Kindness Day in Kentucky in honor of Cody Reeves Gallahue.
Next order of business is a meeting of the Committee on Committees and Rules Committee. Gentleman from McCracken.
Mr. Speaker, I move you, sir, the House would be in recess for a meeting of the Committee on Committees and the Rules Committee at the clerk's desk.
Without objection, the House will stand in recess for a meeting of the Committee on Committees and Rules Committee at the clerk's desk. House come to order. Next order of business is a report of Committee on Committees and Rules Committee. Mr. Clerk, please report.
The Committee on Committees has met and referred the following bills and resolutions to Economic Development and Workforce Investment, Senate Bills 129 and 343. To Families and Children, Senate Bill 122 and Senate Joint Resolution 54. To Licensing, Occupations, and Administrative Regulations, Senate Bill 65. To Natural Resources and Energy, Senate Bills 8, 49, and 100. To Tourism and Outdoor Recreation, Senate Bill 19. To Transportation, Senate Bill 291. The Committee on Committees has reassigned to Veterans, Military Affairs, and Public Protection, Senate Bill 98 from Licensing, Occupations, and Administrative Regulations. The Rules Committee has met and posted the following bills and resolutions to the regular orders for Wednesday, March 18, 2026. House Bills 335, 676, and 689.
Thank you, Mr. Clerk. Those bills referred by the Committee on Committees shall be considered eligible for consideration and action by the committee at discretion of the committee chair. Next order of business is the introduction of amendments. Mr. Clerk, please report.
House Floor Amendment 1 to Senate Bill 5, Representative Holloway. House Floor Amendment 2, the title amendment to Senate Bill 5, Representative Holloway. House Floor Amendment 2 to Senate Bill 59, Representative Roberts. House Floor Amendment 2 to Senate Bill 199, Representative Burke. House Floor Amendment 1 to House Bill 78, Representative Roberts. House Floor Amendment 2 to House Bill 498, Representative Sharp. House Floor Amendment 1 to House Bill 603, Representative Burke. House Floor Amendment 2, the title amendment to House Bill 603, Representative Burke, and House Floor Amendment 2 to House Bill 778, Representative Holloway.
Thank you, Mr. Clerk. The next order of business is adjournment. Gentleman from McCracken. Without objection, your House will stand adjourned until 2 p.m. Wednesday, March 18th, year of our Lord, 2026.